government have decided the lecturers in government and non-government colleges who are in the scale of pay of rupees 525 to 1300 will come to the scale of rupees 700, 1600 with effect from they obtain MPhil of PhD degree. With effect from they obtain.
Please come again. What you are saying?
Government, your lordship kindly see page 53, my lord.
Yes.
Of the writ appeal.
Yes.
Page 53 of the writ appeal, my lord. Government has taken decision. Lecturers of non-government and government colleges who are in the scale of pay of rupees 525 to 1300 will come over to the scale of pay of rupees 700 to 1600 with effect from they obtain the diploma of MPhil or PhD degree.
Diploma of MPhil.
Or PhD degree.
Is this diploma in of MPhil?
Your lordship kindly see page 53, my lord.
In diploma of MPhil.
Page 53 to writ appeal. Annexure 6.
Yes.
I may permitted to place.
Yeah.
In continuation to geo number so-and-so dated 11/9/79, I am direct to say that. Miller?
Page 53.
Page 53.
Yes.
In continuation of geo so-and-so dated 11/9/79, I am directed to say that government, after careful consideration, have been pleased to decide that lecturers in government and non-government colleges.
All right, we have seen. Then
Thereafter, again, Annexure 7, next page, page 54. Your lordship kindly see, that is 83, resolution of the government, clause A.
yes.
Clause A, candidates should have MPhil degree or a recognized degree beyond master level with at least a second-class master degree. And your lordship kindly see clause 2. Candidates who will be recruited to the post of lecturers of affiliated college having the qualification BC above will be allowed scale of 525 to 1300, and those who will be having qualification as at A will be allowed the scale of 700 to 1600. That in 700 to 1600 is minor UGC scale of A, and 525 to 1300 is state scale of A. Petitioner, the appellant, deceased appellant, before appointment.
Just a minute. Six has been cancelled by 7.
Miller,
6 has been cancelled by 7.
6, no, not cancelled, my lord. That is 2 resolution relating to grant of UGC scale of pay issued by the government. Those who have MPhil and PhD degree will be given UGC scale, that is, otherwise others will be given state scale of pay. My humble submission is the appellant, deceased appellant was before appointment has passed MA in Odia in 1st division, securing more than 63% of mark, and also awarded MPhil degree. That is Annexure 2 series, my lord. And after appointment, the deceased appellant has been awarded a PhD degree.
Yes. What is your problem?
My problem is the petitioner while approving the director of higher education, while approving the post of appellant, he was given state scale of pay instead of that pre-revised 700 scale of to 1600 scale that is made for UGC to degree college. That was not given. In 1997, they are given. Therefore, the appellant, decision appellant made several representations. Therefore, thereafter, since government did not consider the case of the appellant in 2005, she filed writ petition before this honorable court. And this honorable court in directed for consideration of the case of the appellant on the basis of Mamata Mahathi case of the Honorable Supreme Court. And in 2019, government finally rejected the case of the appellant. Challenging that
Which is the order under challenge?
order is the Honorable Single Judge Judgment. That is at page 173, Annex 30. In Mamata Mahathi case, my lord, in Mamata Mahathi case, lecturers appointed in the existing intermediate subsequently converted to +2 colleges, and the said colleges got degree affiliation prior to 1489. And underqualified lecturers, even though their qualification was condoned by the respective university and the government, they denied UG scale of pay on the ground that lack of educational qualification, having not MPhil and PhD degree. And the state went to Honorable Supreme Court, and Honorable Supreme Court judgment, you will also kindly see Mamata Mahathi case.
Forget case. You were appointed as what?
As a lecturer in Odia,
In which college?
in the Indira Gandhi Women's College, Shelter Sir Cuttack,
Imparting education up to
up to degree, my lord. Degree,
degree.
my lord.
When?
89, degree was established in 87, 88.
No, but why this question has been framed at page 198?
One page 198.
The other point involved in is whether a lecturer appointed against +2 wing.
My lord,
So you were appointed against +2 wing.
what I humbly submit, my lord,
Yes.
I am holding third post. The second post, sorry, I am holding second post of the lecturer in Odia. The first post of a lecturer in Odia and other disciplines were appointed against intermediate and subsequently converted to +2. All were appointed against +2 wing. And +3 wing was established in the year 87, 88. And Honorable Supreme Court in Ashwini Das case held that the lecturers in the existing +2 colleges and the said college which received after 1489, that is government congress for the +3 degree, so said lecturers are not entitled to UG scale because as per resolution of the government, the college, degree college should be opened in the existing +2 college before 1489. In Ashwini Das case, the government denied UG scale up to lecturers to existing +2 college which have received government congress after +3 degree after 1489. This honorable court held that the cut-off date is illegal and arbitrary. Against that judgment, the state went to the Honorable Supreme Court. Honorable Supreme Court in Ashwini Das case held that cut-off date is illegal and valid are those colleges which have established for +3 degree after 1489, teachers of the state college are not entitled to UG scale of pay. Here in the instant case, my lord, the appellant in which, this is appellant in which she was appointed, the degree college got recognition much prior to 1489, that is year 87, 88, commencing from 1687.
Yes.
Your Lordship kindly see the judgment of the Ashwini Das case. I have also filed. That is, my lord. Page 128.
What is direct payment post?
Direct payments post, my lord, one is appointed. Suppose a person was appointed as a lecturer in the year 83, and after 5 years, after counting 5 years, in case of women's college 3 years, they should be given granted under direct payment scheme. Your Lordship kindly see the Ashwini Das case. May I please, Your Lordship kindly permit me?
Let us see your appointment letter.
Your Lordship kindly see approval, my approval.
Let us see your appointment letter.
My appointment I have not annexed, but approved by the director. My appointment that has been mentioned everything.
If you don't produce your appointment letter, you don't have any case.
I'll produce, my lord. I'll produce if Lordship director will produce, because approval
You
already
did
there.
not produce that before the writ court.
My lord,
You did not produce your appointment letter before the writ court. Let us see, as requested on behalf of the petitioner,
appeal.
1 week time is allowed to
This
bring on
is
record.
This is expired, my lord. Your Lordship,
Huh?
legal have substituted some more time may be kindly given.
Legal year,
This is expired in the, and the legal hair substituted. Lordship give some more time to so that time.
then you did not say that in the beginning.
In the deceased, I am saying the deceased applicant was
Are you making mockery of the
no,
court
sorry,
proceeding?
sorry, my lord.
You are arguing the case on merits.
No, sorry. I extremely sorry.
You have wasted the court's time like this.
Your Lordship, right time. As your Lordship,
Please don't do it in future.
my lord, I'm sorry.
It is unfortunate that after making submissions for 15 years, 15 minutes, learned counsel for the appellant informs this court that the appellant has died during the pendency of this appeal. And as the cause of action survives, the appellant needs to be substituted.
Already substituted. My lord. Already substitution. Therefore, I did on by order dated 22 to 24.
Then why do you want more time?
Because my lord,
When counsel for the is requested on behalf of the appellant, this matter on 1 week, so as to enable the appellants to bring on record, substituted appellants to bring on record the original appointment letter of the deceased employee. Yes.
Item number 2.
Your Lordships, the short question in this matter is,
So before we take up your this matter, in fact, we have reserved a judgment in
Lordships,
nursing matter,
Lordships,
nursing policies matter. Had you given some judgments in that case? Had you,
No,
no.
no, we had not given any judgment, except that that Supreme Court order which says that it has to be done in a time-bound manner. That is there on record.
Oh, that order is there on record. But there are several judgments by Supreme Court
Lordship.
that the timeline should not be,
Yes, should be followed.
should be
In
followed.
fact, in that, because that was there in that nursing matter, and which was the final order. So
Can
that's the
you give
order.
us the previous orders also?
Lordships, I
previous
would
decision?
do my research.
Just give the citations, if possible, by tomorrow.
Lordships,
Otherwise, we will have to do that search.
no, Lordships, we'll do that.
Yes.
Lordships, this is a very short matter. This is regarding contractual employment after a person retires from the regular civil post. And there was a finance department circular which said that people holding this post, their payment would increase from 15,000 to 30,000. It was given a retrospective effect. I'll just take your Lordships to that particular notification. Lordships will find that at annex.
No, but first of all, let us come to the impugned order because you are challenging an order.
Lordships,
So what is the infirmity in that order?
the problem is this, that there were two periods of employment, two contractual period of employment. The court granted us benefit of one period and denied us the first period. And probably because it did not read that particular beneficial notification correctly. So that is why I was taking your Lordships to that notification
No,
first.
what are they?
Your Lordship, that's Annexure 7, page 35. Last paragraph of that notification will clarify. Annexure 7, page 35.
Yes.
Your Lordships will see there's a table there. I fall under serial number 2. That means my pay goes up to 30,000. And the last
No,
paragraph,
no, you are at page 35.
35, Annexure 7.
Yes.
Your Lordships will find that there is a table there.
Yes.
This is about engagement of retired government servants. I fall under serial number 2.
Yes.
And my pay has been enhanced to 30,000.
What is this ORSP rules?
Your Lordships, that's the revised scale of pay rules which come from time to time.
Odisha revised scale of
Yes,
pay.
yes. Your Lordships will see that that order is dated 17/3/2018, the date of the order.
Yeah.
And now your Lordships may turn to the last paragraph of that order, which is para 7, page 36.
Yes.
The fixation of the remuneration on engagement of retired government servants shall come into force with effect from 1/10/2017. So it was given, that new scale of pay was given a retrospective effect. Re-employment pay and remuneration fixed earlier shall accordingly be revised as per this office memorandum. Now, your Lordships, my first engagement is at Annexure 4, page 30.
Just a minute. Yes.
Your Lordships, that is dated 9/8/2017.
Your first engagement.
Yes, your Lordships. After retirement, my
After
first
retirement.
contractual engagement,
You retired in 2011.
Lordships. And
By the
this
time re-engagement
comes at,
came,
yes, 9/8/2000.
you crossed 64 years.
Yeah, I'll come to that, your
Yes.
Lordships. Because I think my case is this, that if you've made a person work, he's entitled to get that pay, which the government ascribes to that particular post. So whatever may be the defect in my initial appointment, which they come out later, after having taken my service, that possibly cannot be a ground. And I think there's a lot of judgments on that point. But your lordships, they don't really, I mean, there's no denial because anyways, the court has granted me the benefit for one more period. So 9/8/2017 was my first engagement. And this continued till 9/8/2018. So when this circular came on 17/3/2018, I wrote to the government, the department. Even in my agreement, it was there that time to time, whatever circulars will come, it will apply. So I said, I deserve the enhanced payment with effect from 1/7/2017 as given in the circular. They did not do so. Then what happened? They re-engaged me. That re-engagement orders at page 38. That is from 29/2018. When I join, I tell them that no, I'll not join in 15,000. You have to give it to me according to the circular. So on protest, I joined. In this scenario, of course, that employment came to an end on 8/3/2019. In this scenario, I approached the court. Now, the court has granted me the benefit for the second period. So in principle, the court agreed, the single bench agreed that I was entitled to this benefit. But for my first engagement, it said, no, you had joined there and you did not protest. But that is not possible because this comes later. And if court denies that retrospective benefit, that is reading down the resolution, which possibly was not required to be done.
Notice. Issue
The
notice.
agreement says that from time to time, whatever memoranda comes.
And it is on a very fundamental principle that you have taken work, you will have to pay. And you will have to pay the amount which you are paying to others in similar circumstances. So that is the
Lordships.
that is our, I think. So accepts notice. Have you served?
Lordship, we give an advance copy, but I think additional copies also we have to give.
Requisite number of the memos of fee be served upon and copy in course of the day. So list this matter on 6 weeks.
Item number 3.
We'll get back with all their judgments. I remember major of them are on the MBBS degree, but probably the
most
same
of them,
logic will apply.
MBBS and BDS, I think.
But the same logic will.
Same logic applies.
Item number
I have
3.
heard the appellant, ma'am.
My lord, under instructions, I am appearing on behalf of respondent number 2 and 3. Under instructions, I am appearing on behalf of respondent number 2 and 3.
The order impugned of the Honorable Single Judge. Lordship may look at page 26. Lordship may kindly have a look at that. That is the order impugned.
Page 26.
Well, at next year,
What is there?
Lordship got it.
Yes.
My application was rejected on the ground that arbitration proceeding is pending.
No. This is your WA 613 of 2024.
My lord,
Yes. Come to the impugned order.
page 26.
Yes.
Lordship, got it,
Page 24 is the impugned order, Annexure 7.
my lord. It starts from 25, the honorable judge's verdict is at page 26. The cause title, then,
So the arbitration proceeding is pending.
my lord.
Then?
That, my submission before my lord would be, consideration of OTS is not dependent on arbitration. It is a question of consideration between the loanee and the institution who has fetched the money. Honorable single, and here your lordship will find what is the writ petition. Writ petition was that,
So whether the arbitration proceeding is legal or illegal.
my lord, arbitration proceeding can be taken up. It has its own field and own jurisdiction. But here is a question, I am just permitting, my lord. It is not dependent. Consideration of OTS, it is between the banker and the loanee.
Mr.
My lord,
What about OTS, whether court has jurisdiction to issue?
my lord, such a question
over.
arose. Such a question arose before the Honorable Apex Court. It's not a matter of right, that I do concede. But
No,
here is a case, my lord.
Court cannot issue direction for OTS.
My lord, your lordship may look at. He has availed loan to the tune of
Sorry,
20
sir.
lakhs.
Sorry.
What is the case of the Honorable Single Judge? I shall only take my lord to the impugned order before the Honorable Single Judge. Took loan of 20 lakhs, paid it.
Sir, we will not go into the merits of the case. The dispute is pending in an arbitration proceeding. If we decide your claim here, then what will happen to the arbitration proceeding?
My lord, OTS is never a claim. It is a only consideration by the banker. Within the norms of RBI guidelines, it's a consideration. What consideration has been given in this case? A consideration is there. Your lordship may look at that. That was impugned before the Honorable Single Judge. Let me take my lord only to that impugned order before the Honorable.
All right, yes.
My lord, that is at page.
Your prayer in the writ petition.
Writ petition. I have also
Your
annexed
prayer in
it.
the writ petition.
I have also annexed it.
Yes, writ petition is attached to. Issue notice to opposite parties to show cause.
My lord,
Direct-
page
Directly
50.
opposite parties, particularly the opposite party number 2, to fix the one-time settlement amount to enable to clear the outstanding.
Page 15. Lordship may look at brief page 15.
Read it.
My prayer is, amount in the statement is rupees 2,15,562.28. If the financial body cannot close the loan under the scheme, we will pay the outstanding principal amount only. Ordinarily, the statement can be revised and sent to us. Then the reply of the bank, your lordship may look at.
Mr. Counsel, what was your prayer before the writ court?
My prayer was to consideration of OTS, my lord.
So that could not have been entertained. That has rightly been not entertained.
Now, impugning this, my lord, your lordship may look at what the consideration of the bank. One line, my lord.
The appellate.
That page 15.
The-
Cannot settle your loan account in the principal amount,
Please, we are dictating order.
as this will impact your civil score.
We are dictating order, Mr. Counsel.
And the arbitration proceeding is after the order of the Honorable Court. That question also your lordship may consider. Arbitration proceeding, your lordship may look at that. I have annexed.
No, my lord, they are well aware of the arbitration proceedings that is pending, that has commenced, my lord.
My lord, your lordship may look at. I have annexed the arbitration proceeding. The date your lordship may take up. Annexure 6, page 18. 23/2/24. Notice was issued. And this order was passed beforehand. That would be my entire submission before my lord. And a judgment also Supreme Court has considered, if your lordship permit me.
The petitioner, the appellate, approached this court by filing a writ petition under Article 226 of the Constitution of India, giving rise to WPC number 27528 of 2023, seeking a direction from this court to which bank?
My lord, it's a NBFC, my lord, Aditya Birla Finance Limited.
To Mr. Counsel, please come.
How it was, I have stopped it, but
You will have to wait till the order is passed.
my lord, it was ran, therefore I ran. I am sorry, my lord.
All right.
I have switched it off, but
All. No problem. We apologize. Seeking a direction from this court. To which bank is this?
Aditya Birla Finance Limited. Aditya Birla Finance Limited.
To Aditya Birla Finance, and so to fix once time settlement amount so as to enable him to clear the outstanding loan. The said writ application has been dismissed in view of the stand taken on behalf of opposite party number that an arbitration proceeding was pending to resolve the dispute between the appellant and the financial institution. Next, when counsel appearing on behalf of the appellant assailing the impugned order has submitted that single judge ought to have adjudicated upon the dispute raised by the appellant despite pendency of the arbitration proceeding. Stop. Next, after having perused the impugned order passed by the single judge and the materials available on record, in our opinion, the writ petition was rightly dismissed, also for the reason that this court could not have issued a direction to the financial institution to fix a one-time settlement amount as was paid on behalf of the appellant. Stop. We do not find any reason to interfere with the said order. This appeal is accordingly dismissed.
Item number 4.
Item number 4, there are 5 matters. In fact, in the past matter, Mr. Rudra Prasad Kar, senior advocate, is doing. I think that is the same matter. I am in the last number 4968 of 2024.
You are
If
in
you're
which
possible,
case?
Yes, 4968.
Who is appearing?
49. Mr. Rudra Prasad Kar, he is appearing in the first matter and the third matters, fourth matters.
And you are in fourth.
So I am in the fifth matters, that 4968 of 2024. Last one. Though I am in 2 matters, that is the third matter 4963 2024 and 4968 of 2024. I will place that 4968 of 2024 because all the documents are attached to that.
So can we proceed?
Yes, I can.
Mr. Kar is not
He's on his legs still.
all.
In fact, if your lordship will look to page 30, this is the guideline, approved guideline by the state of Orissa and the industry department for opening up institution for PDIS course. PDIS course means post-diploma course in industrial safety.
Or PD?
PDIS. PDIS means post-diploma industrial safety.
Industrial.
Yes. That is under the Factories Act. You also know that State Act, that is a Factories Act. page 31. Let's look to page 31. This was of the year 2009, and this is still operating, still in force. Page 31. This is the guideline and approved process for post-diploma in industry safety affiliated to State Council for Technical Education and Training. Let's get it at page 31.
Yes.
Madam. You will also will see that para 2, requirement for grant of approval, no new institution of government, government aided or private institution, we are all private institutions, shall be introduced without obtaining prior approval of the state government. Then these are the detailed stages, how the checklist will be prepared. Then also turn to next page, page 32. Page 32, you will also look to para 5 is the verification of document. 6 is the export committee. Sorry.
We were on page.
You will also be in page 31. Yes. That prior approval is necessary of all the institutions, including the private institutions. Does you get it? Then
Yeah.
kindly come to page 32, sir. Next page. Issue of letter of approval. Then subclass C, expert committee visit as and when the applicant institution is ready for inspection for preparedness of establishment of the proposed institution. The expert committee are consisting 2 officers. Then consideration for issue of letter of approval is by High Power Committee. That means the expert committee report will be considered. They will give no objection. That means the commissioner comes Secretary Industry Department, DTET is the member, Vice Chairman is the member, Joint Director member. And if also will next page, come to page 33, the requirement which has a bearing in my submission, page 33. If you also will see that land, the institution may be permitted to be established with the land norms as per the following table. City area 0.5 acres, but others 1 acres. And this 1 acre has been subsequently amended 1.5 acres so far the other area is concerned. Then build-up area is 5 square meter and other thing. These are the. Then sir, kindly come to duration of the course. It has also some bearing. That is bottom. Admission to different affiliated institutions will be made through central counseling. 1, 2, 3. Duration of the course is 1 year, full-time, part-time, second shift. Does you get it?
You are reading this admission to different affiliated institutions.
Yes, sir. Admission to different affiliated institutions will be made through central counseling. 1, 2, 3. Duration of course, 1 year.
Yes.
Yes. Next page, you also see. Page 34.
1 year
Course.
full time is there, part time also there.
Full time there, part time, second shift. Second shift is part time, but 1 year. Course is 1 year. Next page, page 34.
No, for
Yes.
part-time is also there. Part-time is second shift.
Yes, sir.
Duration of course is 1 year.
1 year.
Maybe part-time or full-time.
Sir. 1 year within bracket full time, part time, second shift. Yes. But the employed students, that I think that is part time. That page 34. Next page. Course fee. Let's get it. Page 34.
Yes.
Course fee, serial number 7. As fixed in case of diploma institutes by the government from different fee structure, lowest in one. Now, this fee structure was fixed way back in 2009. It has not been altered or changed till now. This course fee is concerned. This is the guideline. Now, I am challenging the impugned annexure 2 at page 35. Page 35. A notification was made by the Government Skill and Development and Technical Education Department on 27/7/2022 post-diploma in industrial safety (PDIS) course in line with nomenclature and
So
duration.
challenging this, annexure 2.
That is one of the impugned before lordships. I'm just reading. Keeping in view the standardization of post-diploma in existing institution from 2009. Keeping in view the standardization of post-diploma in industrial safety (PDIS) courses as per AICT norms. For a moment, So far the AICT is concerned, as your lordship knows that under the AICT Act and the regulation, the technical education has been defined under the Act. And that I will show your lordship. Technical institution, if it does not come within engineering and some other technical education which has been specified, other has to be notified in the official gazette by the central government. If it will come within the ambit of AICT. That I will show you lordship, that Act would actuate. Now, my point is this, at the present point is this, keeping in view the standardization of post-diploma industrial safety courses as per AICT norms and pass out student of these post-diploma course and the duration of the duration shall be as per AICT norms. This is for the new institution. I am not concerned because so far as new institution, I am not in new institution, I am an existing institution. The above mentioned approval of AICT, also kindly mark this line. The above mentioned approval of AICT for running PDIS course shall be mandatory from 2026-27 session for the existing institution. This was made mandatory for us from 2026-27. Am I clear?
Yes.
Then kindly come to para 3. It has been observed that many seats in the PDIS course are lying vacant. Hence, status quo as regards to number of seats and establishment of the new institution and approval to new courses shall be maintained during the above 5 years grace period. It may be clarified that if any institution approaches the department with the AICT approval, it shall be entertained. But the statement that was lying vacant, I have given in details. It has been 99% is filled up in all institutions. So that is, I have given in data under the Right to Information Act. That is, I have also quoted that. That is not a question, sir. Now the question is, so far as this year is concerned, because they have made it mandatory from 2026-27. Because till today, AICT has not made any amendment. Your Lordship, just kindly look to what is my grievance. If your Lordship will look to page 98, they said that after 5 years it will be applicable. But what they have made, page 98 is the page 92 that starts the information brochure for admission to this year. Page 92. Government and private institutions down to page 98. That starts from 95 in fact. Page 98.
Yes.
Sir, these important notes, you also turn to page 99, last bold letter. As per the AICT norms, the PDIS course is 1.5 years duration. That means they have adopted the AICT PDIS course is of 1.5 year duration. That is the bold letter. And they have introduced for the courses of 2023, 24, 24, 25 onwards. Though, so far as the AICT is concerned, that will be made applicable to us in 2026. My problem is the courses of fees as has been fixed in the guideline, which was fixed way back in 2009. That also I have got it by way of affidavit. This has not been altered. That years, and within that fees and that fee structure has not been changed by the state because the guidelines still hold the field. So that the 26,000 for the entire year, which was fixed way back in 2009 notification, that still continues. And that is for confined to period of 1 year, as per the guideline. Now they have changed it to 1.5 years. Sir, this is one.
So what
for
do you want? More fee or?
Sir, that is that your Lordship will decide. But the question of law, if your Lordship just have a glance, your Lordship kindly look to the AICT Act.
You want that if it is 1.5 years, then fee should be
accordingly. That should be
proportionately
yes, sir. Otherwise, it will not be, sir. It will not be sustained because we have to pay the salary of the teacher.
We can understand.
Indirectly, you are arguing that this 6 months have to be curtailed.
Because AICT, because you accept the norms of the AICT, according to them AICT, and you said that AICT norms will be applicable so far the existing institution is concerned from 2026. How can you make applicable this year? This is my first argument. The second argument is, if this is this is under the Factories Act, right from 2008-9 till today, this
So
guideline.
you have two submissions. One, that this course does not come within the ambit of AICT Act.
Sure.
And therefore, any decision taken with reference to that is contrary to law.
Right.
And secondly, so far as the fee structure is concerned, the fee structure was decided for 1 year, and now you are enhancing the period to 1.5 years. with,
Thereby, yes.
Ah,
Yes.
therefore-
Second. Third one is, sir, third one, before I take your lordship to the statute, what that, even from 2026, suppose they would make applicable, we are the existing institutions, we have got the affiliation or permission for approval from the state government on the basis of the rule which was in existence till today. Suppose in the state, in the urban area, it is 0.05. Now, according to the AICT norms, it has to be more than one chart. Now, the infrastructure that cannot be enhanced, land cannot be enhanced, all these things which is not, practically it has to be closed. And one thing I think I must, it's my duty to bring to lordship's notice, kindly look to the AICT Act. Sir, what is the technical education? Because AICT is applicable to the only technical institutions. If your lordship will look to, sometimes they are appearing, but they are not a.
because then is
Sometimes
appearing.
they appear.
which part of
105. It's part of representation. It's a 7. Page 105,
Sir,
that moreover, that is the issue. you-
sir.
Highlight.
That is the issue. That is the issue. That's obliged. And I made a comparative chart also. Practically, how institution will be closed. It's
what is that?
Moreover, the 18 months. The needless. An additional 1 year of the students will be needlessly wasted if the same course, which is being imparted in 1 year throughout India, will. be
That is
taught-
throughout India, they have not.
That position cannot be accepted.
That is.
That is the representation which they have highlighted.
Issue notice. London AGA accepts notice on behalf of opposite parties numbers. So. Let requisites we file or service of notice upon the rest of the opposite parties through registered post in AD and speed post within 1 week.
Your lordship, the position is same in respect of all the writ application. This.
Obliged.
Same order.
Obliged.
My Lord, Senior Advocate Mr. Tarun Gulati on the virtual mode, my Lord.
Item number 5.
In item number 5, Senior Advocate Mr. Tarun Gulati on virtual mode, my Lord.
My Lord, I'm appearing online, my Lord.
Yes,
My Lord, this is a matter which had come up before your Lordships earlier, my Lord. Your Lordships had adjourned it.
he had sought adjournment. We remember.
No, my Lord, this issue relates to levy of GST on royalty, where, my Lord, the notifications and the clarifications by which, my Lord, GST is being levied is under challenge. And I pointed out to your Lordships, my Lord, very briefly, without really taking your Lordships through the compilations, that this issue is engaging several courts, including now, my Lord, also.
Mr. Gulati.
Yes,
Mr.
my Lord.
Gulati.
Yes,
Your
my Lord.
prayer number C,
Yes, my Lord.
is it required to be interfered with? It is only a non-disclaimer.
I'm sorry, my Lord, your Lordships are talking about
Is-
the prayer, my Lord?
It is only a disclaimer. It has no legal effect or impact.
My Lord, the only thing is that we say, my Lord, I'll explain why we've challenged it, my Lord. It's an FAQ, your Lordships are right. It's an answer to a frequently asked question.
It is only an advisory.
Correct, it's an advisory. So I'm saying that, my Lord, that advisory, because normally the authorities consider themselves to be bound by such advisories, and the SSCs are not bound ever, and they can challenge it, my Lord. Therefore, by way of abundant caution, my Lord, we have challenged that also. Because ultimately, my Lord, the question is that whether, my Lord, this is effectively a tax on mineral rights. Mineral rights belong to the state. My Lord, this is state's income. on which, my lord, the GST is being charged on a reverse charge basis by treating it as a service. Now, those are the, my lord, issues that have to be decided. Now, by way of a clarification, our my lord, contention is, first of all, Supreme Court itself has said royalty is a tax. There cannot be a tax on tax. That's the primary contention. Secondary, my lord, we say that ultimately we are drawing mineral from the land which the state has granted to us.
Whether
And the
any
state
court
gets-
has decided this issue as to whether.
my lord, there is.
Just a minute,
my
Mr.
lord,
Gulati.
all-
Mr. Gulati, please wait.
Yes, ma'am.
We wait for the Supreme Court's decision.
Mr. Gulati, I think Constitution Bench has, larger bench, has taken up this issue and hearing is concluded. Do you know the position?
My lord, the position is that the 9-judge bench.
That
is
India
going to heard
Cement.
Yes, yes, yes. My lord, the 9-judge bench has fully heard the matter and reserved judgment. My lord, if your lordship sees, I put the orders on record, my lord, at page 58 to 61 of the compilation, where judgment has now been reserved by the Supreme Court and the 9-judge reference, my lord. And so that issues, my lord, already the Supreme Court is considering. But there, of course, my lord, there are larger issues, whether who has the right to tax minerals, my lord, whether the state or the center. Those are other issues. But one of the issues on the India Cement controversy, where it said, my lord, that this royalty itself is a tax, is also a, my lord, matter of reference before the Supreme Court, and which the now judgment stands reserved, my lord, on that.
So do we wait for the decision?
Only
Supreme
problem
Court's
is, my lord, only problem is, my lord, there are, my lord, we are participating in the summons which have been issued, but the state has, my lord, issued an intimation saying pay up, and we are under constant pressure by the DGGI to pay up. My lord, no show cause has been issued till date. And therefore, my lord, I had cited several orders, including that of the recent order of the Supreme Court in
No,
March.
but they are not taking any steps, even so-called.
They are every other day, my lord, we are being called to say you pay up, summons are being issued, we are participating in those proceedings. But we can't pay, my lord, in anticipation today. My lord, there is not even a show cause notice. So
No, but are they taking
Yes.
any coercive step?
Yes, my lord. In fact, there is an intimation which has been issued, my lord. In fact, this writ was, my lord, filed earlier, had to be withdrawn because in the meantime, the intimation had been issued. The court said you challenged the intimation. So we withdrew the writ and challenged the intimation, which is, my lord, annexure A1 at page 68. They've asked us to pay. And, my lord, several courts have granted, my lord, including, if your lordship sees the last order of the Supreme Court, my lord, which is 3.124. My lord, I put it in the compilation at page 38. Supreme Court has also said no further, no coercive action.
They are not taking any. Let us take the response of the State Council.
My lord, then let them, my lord, because two authorities are proceeding against me. DGGI is the central authority and the state authority has jurisdiction over me. They have issued the intimation. I am saying let them make a statement that they will not make any coercive action. They haven't even issued a show cause yet. So they can't, my lord, today in anticipation, start, my lord, issuing intimations to me to say that you pay up. And, my lord, whenever we go for summons, my lord, we are told that you have to pay up. I am in that situation, my lord. The matter, of course, my lord, I bow down. Your lordships were saying that the matter has been reserved by the Supreme Court. We must await. And now I am also saying that. But at the same time, my lord, I can't be taken action against at this stage.
Your Lordship, first of all, I may be permitted to argue so far as the maintainability of this writ petition, Your Lordship. Your Lordship, why I am objecting, Your Lordship, my preliminary objection. This writ petition is premature. Why, Your Lordship? Even the show cause stage has not come, Your Lordship. This is so far as the state GST is concerned, before issuance of show cause notice, for betterment of the fact, for natural justice, Your Lordship, only an intimation has been issued. In that intimation, it has been stated that you are required to pay. Your Lordship, I will go to the relevant page. You are required to pay, Your Lordship. That
if they don't pay, then what will happen?
Show cause notice will be issued, adjudication will be done. Your Lordship, I will go to that. I'll go to on merit, Your Lordship.
Nothing
also.
more than that.
Your Lordship.
Nothing more than that.
So you admit that there is no adjudication as yet.
As yet. Even so far
So this intimation will lead to adjudication if they don't comply with this.
Exactly, Your Lordship.
Right?
Number one. Number two, your lordship, so far as the central GST is concerned, even they have not issued so-called notice, they have issued the summon under section 70 of Central GST Act for investigation. Your lordship, but
Coercive action.
for the non-payment
May
of,
I arrest him?
no, your lordship,
So far as central DGCA is concerned, we are investigating, we are not issuing a final order. So question of arrest does not,
So 70 leads to 69.
no, but
No,
he is cooperating. He is cooperating. There is no, he is cooperating, he's filed their document and he is also, the petition also appeared. So there is no issue. He is now, he challenged the intimation.
now your lordship, so far as my intimation.
In our,
Either of you should make your submissions. Yes.
Your lordship, so far as the tax and royalty, your lordship, my respectful submission before your lordship and all the orders are here. So Honorable Supreme Court, your lordship, admittedly the matter has been referred to larger bench, your lordship, constitutional bench, but Honorable Supreme Court has not granted a single stay order on GST issue, your lordship. I'm placing some of the recent order. Your lordship, preliminary what happened in the year 2000, prior to 2000.
Mr. Counsel, we are not going into the merits of the case because the main matter is pending before the Supreme Court. And for the only issue which you are raising in the present proceeding is that this writ petition is premature. Be that as
Mr.
Mal.
On the one hand, Annexure 1 is there at your behest. That is intimation. That tentative figure you have arrived at on the basis of returns of his transactions. On the other hand, in Annexure 11, the central government intelligence officer has also issued summons. Right. So that has to be resolved. So he may be apprehending some coercive measures by the intelligence.
Let him give one compliance, we will stop our proceeding. Because there cannot be overlapping.
Section 6.
6 to B. Your lordship, I am well aware about 6 to B. Your lordship, we have issued the intimation. We don't know that central GST. So once you will appear and establish the case that central GST, your lordship, it is a preliminary show cause. Once
you decide everything, your preliminary objection, Mr. decide the issue which is being raised by Mr. Gulati, that will also be decided depending upon the final decision of Supreme Court.
I may be permitted to place 2 orders, your lordship.
Your intimation does not invite him to furnish any reply.
No.
Then how do you expect that he will come to you and
I can please
reply? And you are
your lordship,
you are submitting contrary to your intimation.
Yes. But so far as the investigation, so far as DGCA is concerned, it is under progress. He is cooperating. There is no threat at all. But so by intimation is concerned, he has to reply or whatever, he has to take call on that. But your lordship, kindly see the comparison page 60 of the judgment. This honorable court has passed the judgment while challenging the same issue, same issue. This honorable court says, Lord, that kindly see page 78 for a moment.
At that time, Constitution bench has not closed the hearing.
But the same position, all the judgment referred in the compilation.
I was party to that judgment.
Yes. I was
Well,
for
in
the
fact,
petition at that
stated by
point.
Lord Justice Raman's has authored that there is a sea change after that, and that was a show cause notice issued to a unregistered party which was challenged. Your Lordship said we are not entertaining the challenge to the show cause. Virus was not even in challenge at that stage. So completely different issue.
But the core issue is there, whether GST will be leviable on the royalty when this tax or service. That was the issue raised before this.
When main matter is pending before this.
Well, I am not standing on the way. Yes, absolutely correct, Lord. I'll bow down.
We can wait for some time.
Yes,
What is the difficulty?
Yes, Lord. I don't have any. I
Only
don't have
one
any-
judgment of Honorable Rajasthan High Court at this juncture.
Wait first.
That was referred to there.
Which matter is
In that
pending
case.
before?
Your Lordship,
That was also referred to in that case.
Your Lordship.
But- yes, yes.
And
Mr.
these,
Rana.
I
and
am
against,
well aware of that.
and against these
At that time, Honorable Apex Court was not,
It was pending. It was pending.
it was pending,
Yes.
but hearing
And
was not
against-
taken.
Started
Now hearing is
and
concluded,
concluded. Correct.
judgment is awaited.
Correct.
No, where is the order of the Supreme Court, Mr.
My Lord,
Gulati?
the order of the Supreme Court against the Rajasthan.
Reserving the order?
My Lord, that is, my Lord, and if your Lordship sees, 62 to 67 were the procedural orders where hearings were being conducted, my Lord, from day to day. My Lord, the last order unfortunately is not there where it is, huh? My Lord, it's there separately with my learned friend who's appearing in court physically.
Please.
My Lord, it was reserved after, my Lord, your Lordship said, I think, my Lord, had adjourned it, so compilation had already been made.
Mr. Das, is it page 35 of that compilation? Udaipur Chamber of Commerce.
Yes, ma'am. Mineral Area Development Authority, this is the order.
Yes,
ma'am.
Yes, yes, yes,
That is the main.
yes, yes, yes.
Last 2 pages, ma'am. It is admitted at the bar that the core issue involved in the present batch or one case?
One case, my Lord. This is one.
The present case adjudication upon the core issue involved in the present case will depend upon the outcome of the cases pending before the Supreme Court, namely Civil Appeal numbers 4064/1999 bracketed Mineral Area Development Authority, etc. versus Mrs. Steel Authority of India and others, comma, and other analogous cases. Full stop. 9-judge judgment in the aforesaid cases has been reserved by a 9-judge bench of the Supreme Court on, what is the date?
15th March 2024, my lord.
Hmm?
15th March 2024, my lord.
15th,
Yes, my lord.
15/3/2024. First off, awaiting the Supreme Court's decision in Mineral Area Development Authority. And so list this matter on 8 weeks. First off, in the meanwhile, it is observed that the opposite parties shall not take any coercive step pursuant to the impugned notices issued to the petitioner.
Reprivilege.
First off, it goes without saying that the petitioner shall cooperate in the proceedings before
Before opposite party number 3.
opposite party number 3.
And also before 5.
Pursuant to Annex 11, pursuant to Annex 11. Intelligence officer.
Yes, summons.
My lord, only one authority should proceed. My lord, how can we be asked to participate in, my lord, both state proceedings and center proceedings?
Let him give detailed reply. Your lordship will stop the proceeding.
Let him say so.
No, not sought for any
But why don't
reply.
you
Your
take a
lordship.
decision?
Your lordship.
Why don't? What's your steps?
Your lordship.
Sir?
Pursuant to Annex
Can-
1.
Hmm?
No post-production, pursuant to Annex 1. That is
So into an action.
and cooperate with the central government pursuant to Annex 11. That is summons.
All right. Yes, Mr. Gulati.
My lord, all I was saying was that it may be like my lord Justice Raman was remarking, my lord, I can file a reply to the intimation, no difficulty, and I will cooperate with the DGG. I can't be asked.
That is what
Yes,
we
my
are.
lord. That is what I was, my lord, also saying. That's all.
I'm appearing for OP3 only in this case.
No coercive action against Annex 1.
Your lordship.
Cooperate with the central government pursuant to Annex 11.
Your lordship.
That's right. That's all. I'm deeply obliged.
Only we have initiated, nothing more. Your lordship, I am appearing on behalf of opposite panel of 5.
Yes.
Great.
Deeply obliged. Deeply obliged.
Item number 6.
It would W from inadvertent type.
Last order. Last order.
Inadvertently, WA is typed out instead of WP. See. So I'm looking at the office. Could have-
Item number 6.
But wait, please, your lordship. To give you a little bit background of the case, my lord, because I had argued, but still let me reapprise your lordship. But if your lordship looks at page 46, my lord.
Page
46. Annexure 4. But my bid has been rejected.
Yes.
My bid has been
Yes, we
rejected.
remember. We remember the facts.
Yes, my lord. But only on form fee that has not been paid. But if the tender is for, as page 49, selection of successful bidder for design, construction, automated testing station, procurement, supply, installation of vehicle testing equipment, and operation and maintenance at 21 stations. But if you also kind of look at paragraph 15, my lord, at page 10, my lord, page 10. The petitioner company is the leading player in road and rider safety domain. Unique solution provider for transport sector is the largest operator and the first one to start the transaction of commercial vehicle fitness. Paragraph 15, my lord.
Yes.
The petitioner company is the leading player in the road and rider safety domain and unique solution provider for the transport sector is the largest operator and the first one to start transaction of commercial vehicle fitness certificate from manual process to automated fitness testing at inspection and clarification center. These automated inspection and certification center are now called automated testing station. Since 2015, the petitioner is established and operating in major and automated inspection and certification center. The government of India, state government, it has conducted fitness testing over 3 lakhs of vehicles till date and automated inspection certification center. Petitioner is established and is operating in 9 model automated inspection certification center in the Ministry of Road and Transport in various Indian cities, including one at Cuttack, and which is the first one center in state of Orissa. But this shows the petition's credentials so far as the participation is concerned. First, we kind of look at page 56. The rejection order is non-depository GST amount. If your lordship looks at page 47 is the reason they have given. Tender amount submitted, the bid is INR 10,000. Then the page 48, they have said 10,000 plus applicable tax to 11,800 as per section 1, table 1, serial number 7 in the RFB. That
You
is
are at page 48.
page 48. Page 47 and page 48, the reason given, Lord. Page 48.
Yeah.
In the small square inside the page, Lord. 10,000 plus applicable tax, which carries in 11,800 as per section 1, table 1, serial number 7 in RFB. If your lordship turns to.
So let us have their response.
Yes, Marat. In fact, I have paid everything as per the e-portal. They have the e-Nivida that they have given, and as page 192, just one document or certificate is page 192.
And what is the stage of
Page
their-
192? I have not shown, Marat. Page 192. One document, it's a kind of.
Yes.
The e-portal is 79 page. Now, page 192, annexure 21. If a lordship looks at 10,000 I deposited as per the e-portal, payment status is success. If it is less, it cannot be success, Marat. Right side has been paid in
And
time.
if it is more than,
Sir, page 21, Marat. Page 192.
yes.
All the amount that has mentioned in the e-portal has been deposited and it has been success. Right side is mentioned success, Marat.
There is no indication about payment of GST.
No. In the e-portal also it has not been mentioned. And the nomenclature is completely different, e-portal in the RFP. But that is the anomaly they have created
The payment
themselves.
of GST should have been either separately
Yes, included.
generated or inclusive of this.
Absolutely, Marat. They
Is there
should
any
indicate
indication?
specific GST, either it is 5, 14 or 18, whatever be that. That could have been included. And in the other column, they have included GST and mentioned the amount. At page 79, if you I shown that. Page 79. Page 79, if your lordship looks at TPF, is 2,950. This is including GST.
Page 81 should be. TPF. This TPF. Sir,
What is TPF?
Sir, this is
tender processing fee. Tender processing.
Yes.
Tender.
yes, tender processing fee.
Process fee.
Tender processing fee. But if your lordship turns to page 81, page 81, Marat. Annexure 7. The tender processing fee they have mentioned GST 18%. Amount is 2,500. Total is 2,950.
No, but what is the stage of?
Marat, now the technical bid mine has been rejected. Other two, there are 3 bidders. If there is one document I'll show you, lordship, which is part of the tender document, which says that they would consider 2 applicant, 2 bidders, and they will be dividing this 21 station among them. Now I am the only 3rd one. My technical bid has been rejected on this flimsy ground, and other 2 have been considered. It is kept there. Their financial bid has been open, and they have kept it as such.
File your affidavit.
Lordship, may I submit certain clauses of the contract. Here, the technical bid of the petitioner has been rejected.
Mr. Vera,
Only my right.
why don't you file affidavit?
File your affidavit. 2 weeks.
Within 2.
2 weeks time is allowed for the state opposite parties to file counter affidavit. List this case on 2 weeks within first 5 cases. it is expected that copy of the counter affidavit is served upon learned counsel for the petitioner well in advance, so that he may have the opportunity to consider the same and file rejoinder if any. Stop. Yes.
So this should not finalize, man.
No,
Because I am one of the three bidders.
any decision taken by the respondents, opposite parties pursuant to the tender notice. Do you have the details?
Yes.
Tender notice. Please give the details of the tender notice.
Sir, this RFB number, page 49 has the details.
RFP number LX 10-2025 1524 1504 TCS. It is mentioned in page 49, Marat. Page 49 top.
That is subject to final outcome on this case.
But only thing is, Marat, if they give it, then it will be instructions, Marat.
It is coming 2 weeks after today. And it's top of the list.
Lordship, may
But,
fixed a date. Before that, I will file my counter.
We have fixed a date. We have given 2 weeks time. Please try that you file your affidavit within 1 week, so that he may have the opportunity to deal with that. And after 2 weeks, it will come at the top of the list.
Right.
Within first 5 cases.
Right.
This is what we have said.
The thing is, first you can protect my.
Otherwise,
Look at
time.
We have said that any decision shall be subject to final outcome.
Right.
This we have mentioned.
You are successful bidders.
So yes, Marat, successful bidders.
But only they are.
4 and
Their
5
technical bid has been accepted. Their technical bid has been accepted and financial bid has been opened as
Has not been opened.
not
has not been opened.
All right. You can wait also.
So for the
Or else
present,
it-
we are not issuing notice.
For the present, no requirement.
Item number 7.
only 3 are there. Obviously, 2 are the person to be given.
Behalf of who you represent?
Opposite party number 3.
Opposite party number 3. That till date, the financial bid of other 2 bidders who have been declared successful in the technical bid
Right.
has not been opened.
Okay. Good.
Item 7.
Please, your lordship. This is a public interest litigation regarding removal of enforcement from the Gochar land of the village.
Gochar land, go apply that judgment. Judgment is there.
Trinath
Ponda.
Ponda.
Trinath Panda.
Item number 8.
Today also my immense pleasure to place the grievance of Cuttack City before the lordships. As we have yesterday discussed about to some extent that history of the embankment is also necessary to be placed before a lordship, which will help in future. That the king is on the road and that old man is coming to meet the king and he was not allowed. Then he told in a bold house, I want to meet the king only. King allowed him. And when he met, he told the king that you Maharaj, you are looking to the thought situation of the your capital city. Then he told that it is necessary that embankment is to be made all around. For which the name of that laborer was Baimundi. I have saved my entire lifetime earnings. I have not got married, so that my expenditure will be spent there only. And he had at that time no currency was there. He was put that coins, that means small amount. He put in a big putli. Then he handed over to the king. My lord, Maharaj, it is my savings lifetime. Adding with this, please made a embankment around the city. And now this is the ring road all around the advanced city. and we are that happy. But drainage system is still in congested area situation, leaving the VIP areas, posh areas. In the low areas, it is every rainy season 3 times a year. That is monsoon rain, return monsoon.
Mr. Mahanti, please.
Yes.
Mr. Mahanti, is it part of that Cuttack PIL?
Contract PIL.
So it should be heard along with that.
That is also today your lordship has posted it is in the
We
list.
will take up that matter.
Yes, just a minute, Millard. In this matter, we have prayed for because we have a project with us, in which a new project we have.
Madam.
Millard.
Today,
Yes, Millard.
we have that PIL matter relating to Cuttack City.
Yes, Millard.
That is posted today.
Yes,
So
Millard.
this matter will be taken up along with that case when other officials and other
35.
35. Along with 35, it will be taken up. Please wait.
Yes, Millard. Obliged.
Discuss matter along with WPC. No, but don't end them. When the matter is taken up.
Item number 9.
May I lordship, please. But in this matter, the authorities allowed a private unaided school the vacant seat reserved for disadvantaged groups and other sections of people, my lord, students. They have illegally allowed, that's what we have challenged, my lord. My lord, the authorities issued, my lord, kindly come to page 15, my lord. Annexure 1, my lord. Page 17, my lord. The government issued a circular, my lord, how RT Act will be followed throughout the state, my lord. So in this circular, it is categorically mentioned, my lord, the 15% seat, 15% seats to be available to the disadvantaged groups, my lord, SC, ST categories of students, my lord. And another 10% seats to be allocated to the weaker section of this group, my lord. So 25% seats must be allocated as per RTA Act. Thereafter, my lord, one of the private school wrote a letter to the government that we are not getting sufficient students for admission in a school. Therefore, you allow us to that vacant seat will fill up with the general category. My lord, this is against the norms and procedures of the RT Act. Violating that norms, authorities are allowed, my lord. Kindly comes to my lord page.
We'll come back after 5 minutes.
Okay.
But in the meanwhile, you just assure yourself.
Yes, my lord.
That there is some bona fide in your writ petition. Otherwise,
my lord, yes, I'll
when did you file this writ petition? 2024.
Yes.
This matter relates to 2011.
My lord, absolutely right, my lord.
And that was only for that year.
No, my lord. It has continued till 20. The vacant seat has been filled up by this process only till 20, my lord. Why I'm saying, my lord?
So where is the other letter?
Yes, my lord. I'll come to that later. Well, kindly see, in 2019, when you will obtain this by RT information, my lord, we have written write a letter to commission to the minister.
Mr. Counsel,
my lord.
According to you, this system, this was only for a particular year, 2011.
No, my lord.
Please read the order. Don't say no.
Yes, this order, my lord, says that is 11 only.
Yes.
But the process continued, my lord.
Where have you said?
That will obtain, my lord. It will. There are up to 18, my lord. I have the letter up to 18.
Where is that?
Yes, I'll submit.
Where is that?
I have not attached that one. If my lord permits, I'll submit.
No, sorry.
But the process, my lord, itself, the process, my lord, go to the process, my lord.
It is the petitioner's case that 25% of seats in the privately managed schools are earmarked for the children belonging to weaker section disadvantaged group. Stop. The petitioner has brought on record a communication dated 8/11/2011 made by the Additional Secretary to the Government, Department of School and Mass Education, addressed to the Principal DAV Public School, Chandrasekharpur, Bhubaneswar, responding to a letter dated 8/9/2011 of the principal of the said school. Stop. It transpires from the said communication that the principal of the school had informed the additional secretary that the seats meant for the children belonging to weaker section could not be filled up due to non-receipt of the applications during 2011-12. Stop. Responding to the said request, the additional secretary, the Department of School and Mass Education permitted the school to fill up those seats by general category on the condition that they are selected on random basis and that there shall be no profiling of the child based on parental educational qualification, and there shall be no test and interviews for any child/parent. Stop. Learned counsel appearing on behalf of the petitioner has vehemently argued that the said communication is contrary to the policy emerging from the Right to Education Act to fill up 25% of seats in private schools by children belonging to weaker section/disadvantaged group. Also, he submits that subsequent to the said communication dated 8/11/2011, the school has admitted students against said 25% of seats, violating the norms. Stop. In response to queries made by this court, learned counsel for the petitioner has expressed his inability to produce subsequent communications issued by the department permitting the school to admit students. Stop. It is the very fact that
Can I pray, my lord?
Yes, you can.
But the communication is there in page 21. my lord. And even if communication is there, my lord, at page 23, we can be seen, they have allowed, my lord. As my lord mentioned, my lord, correctly, they have allowed. The authorities have allowed fill up that 25% seat, my lord. Page 23, 22, and this one, 21 also. The note sheet were presented, my lord, but the authorities allowed.
Who are you?
But I'm the Abhivavaka Mahasangha, president of Abhivavaka Mahasangha.
For the very fact that are you in a position to show that after 2011 from records?
Yes, madam.
Not from your brief, from your file.
For my file.
Not
For my,
from your file.
no, no, my lord.
Sorry.
If my lord permits, I'll
Yeah,
file.
we are going to impose fast.
My lord,
This
this
writ
organization is
application-
dedicated for the my student. my lord.
This writ application has been filed 13 years after the nearly 13 years after the said communication was made by the Department of Education to the DOE school confined to that particular academic session of 2011-12. Stop. This writ application filed in the nature of public interest litigation, comma, in the court's opinion, is malicious and amounts to abuse of the process of the court. Stop. In order to discourage such practice of filing, such frivolous public interest litigation, we consider it apt to impose cost on the petitioner. Stop. We, in the facts and circumstances, while dismissing the writ application, the petitioner, we impose a cost of rupees 10,000 on the petitioner to be paid by it within 4 weeks from today in the account of Odisha High Court Legal Service Committee. Yes, next.
Item number 10. My lord, can I pray in this case once again, my lord, if permitted?
Yes. Next.
Item 10. My lord, in this case, my lord, I am also in this case, my lord. Item number 10. In this
What is
case,
your name?
my lord, in this case,
What is your name?
Vibhuti Bhushan Chaudhary.
Yes.
My lord, in this case, the authorities, the land allotted for public utility, my lord, are not transferring to the postal department for construction of post office at the CDA, my lord, which falls under Kotak Development Authority, my lord, CDA. My lord, kindly comes to page 15, my lord, annexure 3. The collector,
Just a minute.
my lord,
Just a minute. Whose land is this?
this is land belongs to CDA, my lord, Kotak Development Authority. And there is a procedure that for a public utility, one land must be specified, and it is there, my lord. The authorities are trying to hand over the land, but failed, my lord. That is what I am trying to convince, my lord. Kindly comes to page 15, my lord, annexure 3. The CDA Kotak Development Authority wrote a letter to the collector that
How many public interest litigations have you filed?
It's 2, my lord.
Only.
Earlier, a number of PILs have been filed.
How many?
I am not remember, but it's around.
No, you'll have to tell us.
20, around 20. I filed.
Around 20.
Yes, my lord.
So are you resident of this business side project area?
Yes, my lord. The petitioner is the president of Senior Citizens Association, my lord.
Who is for the CDA?
CDA, they have their own panel. Mr. Dayanand Mahapatra, he generally appears for CDA. They have a separate panel.
Tell us by tomorrow.
Please.
What is the matter about?
Please.
Yes.
Item 11.
11 plots of Lordships are pleased to grant me plots indulgence on 2 occasions to comply the order. There was a direction by the Supreme Court by the contender to consider the application for transfer of the land, Milords. And as it seems, Milords, he has not yet complied with Lordship's order. She may either last chance to
No, no last.
This order is made known to him.
Yeah.
This order of 3rd April
Yes.
24 is made known to the contemner.
No, so I written to him, Milords. I written to him.
You communicated this order.
Milords, I've communicated a letter to him on 5th of April, stating therein that adjourning have directed the last chance to comply the aforesaid order, Milords.
So who was required to comply?
Milords, Additional District Magistrate Mayurbhanj, Milords, Baripada.
The petitioner in the present application has raised deliberate disobedience of this court's order dated 28/2/2023, passed by a coordinate bench of this court in WPC number 20117 of 2022. Stop. By the said order, the additional district magistrate. What is his name?
Vibhuti Bhushan Nayak, Your Lordship.
Magistrate was required to consider the petitioner's application for transfer of
Lease, Milords.
Transfer of the lease.
for transfer of lease in terms of one of the conditions of the lease agreement. So stop. The said order has not been complied with. This application was taken up on 21/2/2024. Earlier, when 2 weeks time was granted to the contemners to file a reply and inform this court as to whether this court's order has been complied with or not. So, despite the court's order, no reply came to be filed by the contemner. So, the court had taken a lenient view when the matter was taken up on 3/4/2024, despite the fact that this court's order was neither complied with nor a reply as required required under the order dated 21/2/2024 was filed. Full stop. In the order dated 3/4/2024, the court had made it abundantly clear that if the order dated 28/2/2024 passed in WPC number 20117 of 2022 was not complied with without any valid reason, comma, the court shall initiate contempt proceeding against the opposite party / contender. Next, Mr. L. Samantarai, additional government advocate, has informed that this court's order dated 3/4/2024 has been communicated to the opposite party member,
Only opposite party members.
the opposite party, but additional district magistrate.
Additional district magistrate.
Full stop. But he has received no instructions. Stop. Next, in such circumstance, the court is left with no other option but to initiate contempt proceeding against the opposite party for deliberate violation of this court's order dated 28/2/2023. Stop. Let him be personally present in court on 1 week. Stop. He shall be under obligation to file his proposed reply stating as to why he should not be held guilty of deliberate disobedience of this court's order and be not adequately punished for his conduct. So, next, let a copy of the present order be communicated to the Chief Secretary of Orissa for him to ensure that the opposite party is present in court on the next day.
Much obliged.
Yes.
Item number 12.
That's in item number 12. Lordships were pleased to dispose of the writ application directing the collector Ganjam to consider the representation wherein the petitioner prayed for a bypass road, new bypass road to a BG town in district of Ganjam. The executive engineer has also been noticed. They have been noticed. He needs some more time because today the nomination is going on. So he has only requested.
Sir, he wants a bypass road.
No.
So if a person files a writ petition that there should be a bypass road for Bhubaneswar town, and therefore the High Court, if the High Court is directing for consider representation, you do it within 1 day or 2 days. Is it possible for the state government to take a decision on the basis of representation that there should be a bypass road?
No, because there was a direction to give
direction, then do it.
No, notice and hear, Lords. So we have issued notice. That is why that is the problem, Lords. Next week only he can do it. Where notice has been issued, executive engineer has also been noticed.
As requested on behalf of the opposite party, list this matter on 2 weeks.
Item number 13.
Report full compliance of this court's order, disobedience of which has been alleged in the present contempt application. Yes.
The 13 complied with. My friend is also present there.
It is stated at the bar that this court's order dated so and so has been violation of which has been raised in the contempt application has been complied with. The contempt proceeding stands stopped accordingly.
Item 14.
14th also complied with. I have already filed the compliance affidavit on Miller's 10th for Miller's. Speaking order has been passed by the Miller's opposite party at Annexure A/1.
Is admitted at the bar that this court's order, violation of which has been raised in the contempt application, has been complied with. Dropped. 7. Yes.
Item 15.
The 15, your lordship directed me to serve a copy on this. Your lordship.
Where is the order?
Copy served to municipal council within.
Where is the order passed by this court?
That order is at Annexure 1.
Page 11. it's
Page 10, Lord, operative portion of the direction at page 10.
Page 11.
Yes, paragraph 3. Mr. D. Naik, Learned Counsel, appearing for the Commissioner, Cuttack Municipal Corporation, states that since the kisam of the land has already been changed, as has been informed by the Tahsildar, the Cuttack Municipal Corporation will take care of by constructing the road as quickly as possible, but not later than 3 months from today. It is accordingly ordered. They have to.
In this case, the opposite party has different ego. Some problem.
They have given undertaking.
After the land has already been surrendered to you.
Not Smasan. It is a
It's a
private land.
private plot. He has surrendered to you for construction of road. So for that you want a reply and review.
This Commissioner Cuttack? Huh? Is he busy in something else? He has road, he has land, which he was not having. The Cuttack Development Authority was not having the land. Because of that, the road was not being constructed. Now the private persons have handed over you the land and you are not doing anything.
Some problem, land is situated in the Smasan Mela.
Huh?
Smasan.
There is what?
Just Smasan land. So, some boundary is there, so this is difficult on the part of the.
Mr. Tahsildar has changed the status and it was a private plot. Status of the land has already been changed. Then where from this Masan came? You are creating something else.
Only to flout the order.
Review is pending.
Very unfortunate.
All right. Learned Counsel appearing on behalf of the contender states that this court on that a review application has been filed seeking review of the order dated 2/11/2023, violation of which has been alleged in the present contempt application. What is the number?
Number 50 of 2024.
Please say loudly. Please use
50 of 2024.
50 of 2024.
50 of. List this matter, list this contempt application along with review so and so on what date thereof after 2 weeks constitute.
Item 16.
Item 16, one password, my lord. Item 16, one password.
Let us see. Yes, so it's for the other side.
Yes, I'm for the state clause. If your lordships kindly come to that amendments made in paragraph 9, page 7 of the contempt petition law. Because this contempt has been moved before lordships after obtaining Milord's liberty from the honorable single judge to move your lordship because they said that writ of
No,
appeal is.
this is item number contempt 2720.
Yes, Lord. 2220. It was before the honorable.
20.
Yes, Lord.
2720.
2720.
Oh, sorry. I'm sorry, Lord. 2720. I'm sorry, Lord.
2720.
Yes, Lord.
So what is the order?
Yes.
Not been able to get it because I don't know the background.
Regularization of DEO.
Yes, Lord.
May I permit?
They are resource persons. They are working as resource persons, and there was a direction for considered case for regulation, and the order was challenged by the state in a writ of appeal. The petitioners filed contempt before the honorable single judge saying that the order of status quo passed in the original writ application has been violated and their terms of engagement has not been extended. Honorable single judge has disposed of the contempt petition. If you also kindly look at saying that this was honorable single judge cannot pass any order and granted liberty to move. If you also kindly come to page 30, paragraph 4 of the order of the honorable single judge. However, on a careful analysis of the order dated 4/4/2020, this court observed that the same has been passed by the division bench of this court in writ appeal number 692 of 2022. Therefore, it's a case for violation of order passed by honorable division bench. Accordingly, it is open for the petitioner to approach the honorable division bench for violation of order dated 4/4/2023. You'll also kindly look at the writ appeal number. It is 692 of 2022. And now in their petition, they've stated that similar matter, the state has gone on in the Supreme Court, and Honorable Supreme Court has not direct proceeding in the contempt cases pending before this Honorable Court. It is their averment in the contempt petition. So in view of that, they can await till disposal of those SLPs before the Honorable Supreme Court.
The petitioner did not allowing the discharge his duty. Petitioner not allowing the discharge his duty, my lord.
No, but is there any order, stay order passed by?
Yes, my lord. Page 19, your lordship.
Then as on date, they have not committed any offense.
Initially, the petitioner approached this honorable court.
Mr. Counsel, there is an order passed by the Supreme Court staying this court's order.
That matter is different, my lord. That matter different. What my learned seniors testing, that matter is different, this matter. Page number 19, kind of have a glance to page number 19, your lordship. Initially, the petitioner approaches the single bench for regulation of service. This honorable court disposes the matter Thereafter, the state government has preferred the writ appeal. The writ appeal is taken up by this honorable court. The status quo is maintained, again remanded back to single bench to adjudicate afresh. Thereafter, the petitioner did not allow his discharge his service. Thereafter, the petitioner did not allow him by the authority to discharge his duty. That's why the contempt application arises.
Have you seen your paragraph 9? Place it.
Similar matter is pending before the
Place it.
Yes, madam. It is worth indicating here that the order and judgment dated 9/9/2021 rendered the WPC number so and so to Patwaban Dattadas versus State of Orissa and others was confirmed by the Honorable Division Bench of this Honorable Court by the judgment dated 12/4/2023 in WA number 777/2021 and the batch of cases. Though the state has challenged the said judgment in a batch of SLP, yet there has been no stay against the judgment 12/4/2023. But only order was passed in that. In the meantime, further proceeding in the contempt petition is filed before the High Court alleging non-compliance of the improved order shall remain stayed. The petitioner reserves the right to produce copies of the order of Supreme Court if required at the time of hearing.
Then
My lord,
it is your petition. You are bringing to the notice of this court this fact. Then how contempt is?
lord, that
And why did you file the contempt petition? Knowing well the order of the Supreme Court?
the petitioner did not allow him service to discharge his duties. That's why. That regulation matter is pending, my lord. The petitioner did not allow him discharge his duties
Petitioner
despite of
is alleging disobedience of this court's order dated 9/9/2021, passed in WPC number 19951 of 2020, which was disposed of your writ petition was 40037.
Yes, boss.
On the report. 40037 of 2021, dated 21/12/2021. Which was disposed of in terms of WPC number 19951 of 2021, bracketed Pati Tapavan Datt Das and others versus state and others. Bracket closed. Following is the statement made in paragraph 9 of the application. Full stop, it is evident. Next. Paragraph 9. It is evident in view of the statement made in paragraph 9 of the contempt petition, as noted above, we are of the view that filing of present contempt application is misconceived. So this application is accordingly dismissed. Yes.
Item 17.
There is a delay of more than 250 days in filing the appeal.
200?
250 days. This may go to the appellate party.
What is the explanation?
Petitioner approached the legal aid authority. The legal aid authority handed over the game by under Annex 1, 29/4/2023, engaged me to file appeal, and thereafter I write to the petitioner to come for certain instruction. But since he was ill till 31st July 2023, After getting recovery from, and immediately I have filed the appeal. And that's Annexure 1 is the letter of legal aid authority, and 2 is the medical certificate. Opposite parties are State Secretary Revenue Department and Collector Noyagarh. Notice me.
No, why notice?
The delay cause is not intentional, but
Let us see the
due to delivery lapses.
order passed by the learned single judge.
That is at page 20. Page 20 of the memorandum of appeal. The petitioner filed this writ petition seeking direction to opposite party number 2 to issue appointment order in its favor in the post of junior stenographer against unreserved male vacancy, relaxation of upper age limit, and to give all consequential service benefits. Since petitioner eventually seeks relaxation of upper age limit, such relief cannot be granted at this stage. Thus, this court is not inclined to accede such a prayer made in the writ petition.
What is wrong?
Milord, the petitioner, during the year 94-95, there is a recruitment for the post of junior stenographer. Though the petitioner was
30 years back, the
30.
recruitment process.
Milord, since then he is fighting the litigation. Immediately he has.
What will he get finally?
Milord?
What will he get finally?
That I can say.
After 30 years?
Though the tribunal directed the collector to engage him if work is available, but the collector avoided. And representation, every representation has been rejected. The petitioner has obtained a document on the right to
All right. So on when the advertisement was issued in 1994.
94-95.
Huh?
94-95.
What was your age on that day? In 1994.
Well, now present I am 58 years old.
You are 58 years. So what was your age? 34. What was the age prescribed? 24.
Milord.
So, what was the age prescribed for in the advertisement?
Milord. No, I was satisfied all the conditions of the advertisement. Then in the recruitment process, I was also empaneled at serial number 7.
Mr. Sharma,
Milord.
my lord, just to know what is the age prescribed in the advertisement.
Advertisement is not with me.
You are challenging an order passed on 10-10-2022.
Milord.
Please come to the order and tell us what is wrong in the order.
Milord, during that period, I was in normal age limit. But since the
So that is what my lord wants, just to know what is the age fixed in the advertisement so that we can assess or ascertain whether the learned single judge has went wrong in deciding the issue which you have raised.
Then let it come on a Monday, so I will satisfy lots of. The advertisement is not, let it come on Monday, I will satisfy.
Let it come after 4 years or 2 years.
Just Monday.
In the meanwhile, you will attain the age of superannuation. What relief will you get? Even if we allow, you are 58 as on date.
That's good. That's why in the way, I let it come Monday, I will satisfy lots. Milord, kindly just, I'm showing one thing. Page 23. The person who is in outside not in recruitment process, he have been assigned with the job. But in spite of the repeated order passed by the state administrative tribunal, the opposite party number 2 didn't consider my case. One of order is page 16.
No, we are not going on. The dispute relates to a selection process initiated in the year 1994 for the post of junior stenographer. In which department?
In the review collectorate of Noyagarh.
Under the collectorate of
Noyagarh, district Noyagarh.
the district Niagara. So stop. The petitioner has put to challenge an order passed by a learned single judge of this court dated 10/10/2022 in WPC bracketed OA number 1078 of 2019, whereby a single judge declined to issue direction to opposite party number 2 to issue appointment order in favor of the petitioner by relaxing upper age limit. So stop. Learned counsel for the petitioner states, appellant states that the appellant has attained. The appellant is, as on date, 58 years old. So stop. We do not consider it to be a fit case to entertain challenge to the order passed by the learned single judge, order passed by the learned single judge in the facts and circumstances of the case. Stop. Since the appeal has no merit, is accordingly dismissed.
Item number 18.
My please, Lords. In this case, there is a delay for 62 days, my lord.
52.
62.
Merit?
Petition has been filed, my lord. Limitation petition filed, my lord. My lord.
Yes.
Here, my lord. Since petitioner was ill, my lord, he could not file the appeal, my lord. He was suffering from viral hepatitis. During that period, my lord.
No, where is the order?
Order, my lord, lords, you can have a glance. The order annexure 3, my lord, to the writ appeal, my lord, page 26. The background of this case is like this, my lord. The petitioner applied for the post of physical instructor, my lord, part-time physical instructor, pursuant to advertisement made in the year 2013, 15, my lord. And
You are challenging this order in Annexure 3.
Annexure 3, my lord.
Which was passed at your instance.
Well, that was a past, my lord, because, my lord, this is the draft merit list was prepared in the year 19, my lord. And that should have been approved by the director of sports, my lord.
Mr. Counsel, based on your submission, the order was passed. What can be done?
That will take
accordingly, it is direction be issued to opposite party number 2 to take immediate steps to verify the authenticity.
There, my lord, but
till then, my lord, there is apprehension of the petitioner, my lord, that delay may cause the, my lord, and the petitioner will not be get employment, my lord. This is a case of 2015 advertisement. In the year 2019, my lord, that merit list was prepared and referred to the director sportsman for
Sir,
approval.
whichever order was passed, that was passed at your instance.
If your lordship.
The present intra-court appeal has been filed against an order dated 28/7/2023, passed in WPC number 2219 of 2020. Stop. It is manifest from the impugned order dated 28/7/2023 that the same was passed based on the submissions advanced, accepting the submission advanced on behalf of the petitioner. Full stop. For the benefit of quick reference, we reproduce here and below paragraph 6, 7, and 8 of the impugned order passed by the learned single judge. Full stop. Next. As the impugned order by the learned single judge has been passed, accepting the submission made on behalf of the appellant, we see no reason for interference with the said order in the present intra-court appeal. From this appeal is devoid of merit and is accordingly dismissed.
Item 19.
19, my lord, 3 admitted position, my lord. 1, there is a delay of more than 700 days. Second, on the same, this relates to RSP, my lord, revised assured career progression. On the same issue, the writ petitions which are dismissed on the ground of delay, we have moved the Honorable Supreme Court and we have a stay. I will give that order to my lord. And third is, my lord, may kindly look at page 86 for a moment. 86, this Honorable Court directed to implement the order of the tribunal. Now we have challenged that order, we have not challenged the original order of the tribunal. These are the 3 admitted position, my lord.
How can you challenge the order of the tribunal in this appeal?
We cannot, we have to file a writ petition for that. If we are to challenge that, what I was submitting before my lords is, we have challenged the order passed by this Honorable Court, Honorable Single Judge, wherein a direction was made to implement the order of the tribunal. Because the respondent had come before this Honorable Court seeking that there is an order in my favor, it's not being implemented, so this Honorable Court directed to implement the order. We have challenged that order, but we have not challenged the original order, the order which is required to be implemented.
And that, my lord, that common order, my lord, I'm for the respondent number 1, my lord. In that common order, 13 cases were decided, out of which 7 they implemented. In one case, they filed a writ petition before this Honorable Court and that was dismissed. Thereafter, carried to the Apex Court, where that was dismissed and implemented. And now they filed this case, my lord. So that's in that common order already been tested by this Honorable Court, so also by the Apex Court in other cases.
But in other similar matters, we have gone to Supreme Court.
And the division bench in one of such case, my lord, if your lordship permit me.
The brief facts of the case are that there was an order passed by the Orissa Administrative Tribunal dated 9/1/2019 in OA number 1376 of 2018, which was not being carried out by the authorities. Stop. This meant the respondent filed a writ petition before this court, which gave rise to WPC number 37 of 2022 and came to be disposed of in the very first day when the matter was taken up on 5/1/2022 with her direction to carry out the order of the tribunal. So stop. It is not in dispute that the order of the tribunal has not been challenged by the state of Odisha, bracketed the appellants. Stop. This is one aspect of the matter. Next. Secondly, the present intra-court appeal is barred by limitation. An application has been filed under Section 5 of the Limitation Act for condonation of delay. Condonation of 700 days, 700 days.
770.
More than 700.
770 days.
770. 770 days. Oh, stop. Following is the explanation put forth in paragraph 4 of the application seeking condonation or delay, IA number 1148 of 2024. Stop. We are not satisfied that the appellants have been able to make out a case that there was valid reasons justifying the delay of 770 days in preferring the present appeal. 772 preferring the appeal. Stop. IA number 1148 of 2024 is accordingly dismissed. Consequently, the writ appeal stands dismissed.
The tribunal has followed its earlier two decisions
Well,
in this batch.
well, that's a fact, madam. But in similar cases now, but now we have not challenged that. I cannot agree.
One order in respect of others already been implemented.
Item number 20.
Here, my lord. My lord, may kindly see the order dated 28/3/24. We are grateful, my lord, because of my lord's indulgence in protecting us. My lord, may kindly record my statement. We have already given released the provisional family pension in favor of the person. Provisional for this reason, my lord, because we pointed out to my lords that the whereabouts of the deceased husband was not known from 94 till his death in 2009. So we are collecting all the records, all the documents from the last station where he was relieved from thereafter he didn't join. And we will be releasing the family pension
within a period of 4 weeks, if my lord may kindly grant us. Thereafter, my lord may kindly take up this matter for.
As requested on behalf of the appellant, Mr. Mishal and AGA has informed this court that in view of the observations made by this court in the order dated 28/3/2024, the state of Odisha has revisited. You're revisiting the claim.
My lord, we have, and we are going to grant her the family pension.
State of Odisha has decided to grant the writ petitioner family pension in accordance with the provisions under Odisha Civil Services Pension Rules 1992. Stop. I'll list this matter on 4 weeks. By 4 weeks, you'll do it?
Obliged.
4 weeks.
We have already disbursed the provisional family pension.
Final, do it final, and then.
Item number 21.
In item 21, my lord senior has today filed an affidavit responding my counter affidavit filed by the collector. With a lengthy affidavit, he has served the copy to me just now. So what I gathered from this, he has raised many factual allegations and denied. I have to take instruction because it is a very sensitive matter. I have to take instruction.
Sensitive, how sensitive?
Miller, we are saying that the land is already acquired and thereafter he purchased the land. He is denying it, or all these factual events have to be again replied back by my.
It's a very old matter,
Yes, my lord, it's an old matter. Yes, I understand.
Yes.
Yes, I have filed the reply.
Whether new facts have been brought on the court.
No. Whatever prevaricating statements they have made at different stages, I have given in gist in this rejoinder affidavit.
It is stated by learned AGA. AGA,
Yes.
Representing the state of Odisha, that the rejoinder which has been filed on behalf of the petitioner, a copy of which has been served upon him recently, is requires consideration. Requires consideration. So stop. List this matter on when 1 week.
My lord, may I pray one thing, because I have to take instruction from the collector. Now everybody is in election duty, the election. Can I pray for a long time, because I have to get the records? Otherwise, if your lordship will direct, I will.
3 weeks. 3 weeks.
4 weeks. The election will be over after 4 weeks.
In fact, they have already filed the records, whatever records they had inquired, they made
I have to see
in the counter.
What you have.
I have only pointed out the discrepancies from their records.
So sometimes they need it. Otherwise, he will have to do everything. Mr. Mohanty will have to do the whole exercise.
Here the CDA has returned the land to
They
the.
say, at one stage, they said that we denotify it.
That is
And
in
now
respect of
in
a
the
plot
counter,
which
it is
does
said
not
that
belong
we have
to me.
utilized it.
He has mentioned a wrong plot in his writ petition. That is why that response. That I will clarify to your lordship. 4 weeks.
4 weeks.
Item number 22.
May I please, Lordship? All three matters, my lord. For my lord's convenience, I have prepared a short note. I'm handing it over.
In item 22, my lord, the last occasion your lordship allowed me some time to file the counter affidavit. In the meantime, I have already received the para-wise reply.
Come this side. Come this side.
My lord.
Yes.
Well, in last occasion, your lordship allowed me some time to file the counter affidavit. In the meantime, I have also received the para-wise reply.
If your lordship allows me 2 weeks time more, then I will be
As your
able to
lordship.
file the
As your
counter.
lordship. 2 weeks further time is allowed for
The opposite party number 1.
the opposite party number 1 to file counter affidavit by way of last indulgence. So is this matter on 2 weeks?
Obliged. Item number 23.
I may be pardoned, your lordship. Your lordship, in item number 22, the name of Mr. J. Pradhan and associate may kindly be deleted. The consent has already been given.
23,
22, your lordship.
22.
Yes, your lordship.
J. Pradhan is appearing for
Opposite party.
22, I am
party
for
number?
I am for the petitioner in all 3 matters, 22.
Name is appearing J. Pradhan.
Your lordship, consent has already been given.
He was the previous counsel, mistress.
In appearance. You file your appearance.
Habit of filing any appearance, so they mention it for the purpose of case and
I understand.
J. Pradhan.
J. Pradhan.
For
Mr.
opposite party number?
Mr. Panigre is appearing for the party for whom J. Pradhan was
He
appearing.
is opposite party number 1.
Yes, your lordship.
You are for?
No. Bhavani Panigre is
Where is
appearing.
Mr. J. Pradhan? Are you J. Pradhan?
No, your lordship. He's in another court.
So where is Mr. J. Pradhan?
Your lordship, if he will be appearing, if your lordship permits, then he might.
You are proxy counsel on behalf of J. Pradhan.
Yes, your lordship.
Should we do it? Mr. J. Pradhan is not here,
Your lordship.
and you want us to record his presence in our order.
Your lordship, if your lordship permits, he'll be here after lunch.
No, J. Pradhan is the associate of senior counsel Samir Misra. He has given.
Counsel, if you have to give your slip, it's a different matter. Otherwise, don't request us to pass incorrect orders. Heard, Mr. J. Pradhan? Can we say that?
Well, in fact,
No, we are not asking. He requests J. Pradhan's name to be recorded in our
no,
order.
that should be deleted in view of the previous order. In view of the
Deleted.
previous
You
order
want
passed by
that
the
to be
sole court.
deleted.
Oh,
J. Pradhan would delete. Should be clear.
note of
You
submission
have
taken.
superseded J. Pradhan
Mine.
and associates.
Yes.
Name of J. Pradhan and associates
Maybe
deleted.
The note of submission be taken on record.
Associates will be deleted from the fog list.
The note of submission I filed may be taken on record along with the decision.
Yes.
Item 23.
Made please, Sir Lordship. Lordship, the brief background of this case is like this, my lord. The predecessors in interest of the petitioners, my lord, after coming to know in 1990, my lord, that their lands were taken by the state without any due procedure of law, they have filed a civil suit, my lord, in the civil court in 1990, claiming for right title interest and recovery of possession. There, the state has filed the written statement by claiming that they have already acquired the land in 1961, and as they are in continuous.
So is this a PIL?
No, my lord. This is a land acquisition. The petitioners, this is the admitted fact that the land belongs to the petitioners, my lord. There, the state has claimed that, my lord, the land has already been acquired since 1961, my lord. And they are in continuous possession. So they have also claimed adverse possession against the petitioner's predecessors in interest, my lord. After coming to know that, my lord, that the land has been acquired by the claim of the state, the petitioners have approached the appropriate authority for disbursement of compensation, my lord. They have not taken any steps. In 2001, my lord, these petitioners have filed a writ petition before this honorable court. This honorable court disposed of that matter by directing the opposite parties to consider their representations. Their representations were, my lord, rejected. By that rejection order, my lord, by challenging that rejection order, the petitioners are before this honorable court. Here, my lord, after admission of this writ petition, the state has filed the counter affidavit. Again, the same stance was taken, which was taken in the civil court, that the state has already acquired the land since 1961. Interestingly, they have not stated about the adverse possession which was stated therein in the civil court. They have stated herein in the counter that yes, the state has already taken your land through land acquisition proceeding. My lord, after considering that aspect, this honorable court by order dated, my lord, order number 10, lordship may kindly see. Dated, my lord, 22/2/23, 22nd to 2023. That is order number 10.
Yes.
My lord, this honorable court has directed the state authorities, if you are claiming that the land has already been acquired by you, then you produce the section 4(1) notification or section 6 notification.
All right, we'll take up later.
Obliged. Relating to section 4(1) or section 6 notification. Lord, now lordship may kindly see the order number 23, dated 2/1/24. The relevant paragraph would be, my lord, paragraph number 4. The affidavit was filed. May I read, my lord?
Just a minute, page.
My lord, the order of this honorable court, order number 23, dated 2/1/24.
Yes.
Lordship. The
It's a
paragraph.
very old record, very old record.
My lord, but I am referring to the order passed by this honorable court in 2/1/24. There your lordship will find in paragraph 4, in view of the affidavits filed by the opposite party number 3, learned additional government advocate wants to take specific instruction as to whether any notification under section 4(1) and 6 of the LA Act are available or not. And if no such notification will be available, then fresh notification can be issued for acquisition of the said land so that compensation amount can be released in favor of the petitioners. For that purpose, he prayed for 2 weeks' time. Further, in view of the above, call this matter after 2 weeks, by which date learned additional government advocates shall produce the effective steps taken by them to resolve such dispute, since in the meantime more than 60 years have been passed and the petitioners have been deprived of getting the compensation amount for acquisition of their land. After this order, my lord, my learned senior, in order number 25, has admitted that the petitioner's land was not acquired. Lordship may kindly see order number 25, dated 30/1/24. Learned additional government advocate has contended that.
Then what happened?
My lord, since 1990, my lord, the state has consistently taken the view that the land was acquired since 1961, and they have also claimed adverse possession against its own citizen, my lord. Now in 2024, my lord, 31/24, my lord, after a span of 34 years, they have conceded to the fact that the petitioner's land was not acquired, my lord.
So what
After
has
that, they have filed the
what has been
affidavit.
built over the land?
My lord, there were some constructions they have built.
Which construction?
My lord, the official quarters they have constructed. Official quarters for government quarters, my lord, they have constructed. They have admitted that fact.
Where?
My lord, in the petitioner's land.
Where?
My lord, in Dharamgarh district, Kalahandi, my lord.
Area?
My lord, Dharamgarh, my lord, district, Kalahandi.
What is the area?
My lord, area I am saying. My lord, the scheduled land is Khata number 46.
Area?
Area, my lord, 5.22 decimal. Acre 5.22 decimals.
Yes, you acquire them.
Yes, in fact, Lordship sees.
See, we have two options.
Yeah.
Either we can direct for demolition of all these structures which
Right.
you have made, or you will have to pay the compensation
Yes.
under the new act.
Yes, here in fact, the Lordships were pleased to grant Lord's authority on various occasions to produce the 4 and 6 notification.
All right,
If
now
we-
you have taken a specific plea.
That it's not available in spite of thorough.
No question of available. It has been recorded in the order.
Ah,
that
right,
It was
yes.
never acquired.
Yes.
So if it was not acquired,
Yes.
then you will have to compensate.
Right, no, that is the that is the stand taken, no, I cannot improve upon because that was the stand before the court below in the suit that we have acquired, but we could not produce any relevant document showing that these land has been acquired. But we took a plea that because of the fact that it has been the name of the persons have been deleted from the record of rights, and it has been recorded in the name of state government. Presume that the land has been acquired in addition to some whole, because at that time 32 acres of land were not acquired. So only question is not. This is the only point. I will file a short note or submit to this. I don't want to honestly take adjournment before Lordship. Only by Monday I can file that note or Lordship can dispose of this.
And if you have not taken any, you have not acquired the land, then you should acquire it.
Right, only Lordship can dispose of and whatever it is.
No dispose of. You seek instructions, let this stand be taken by the state government. It is in their interest.
Yes.
That
Yes,
they should, that they proceed for acquisition of the land
Right,
in accordance with the.
No, we have to acquire means under the new act, we have to acquire fresh notification has
Yes.
to be made, my lord. Right, well, Lordship may grant me sometime, I will file that affidavit of the authority concerned.
The petitioner approached this court with a grievance that without resorting to any proceeding for acquisition of land in accordance with law, the state opposite parties acquired his land upon which certain government buildings have been constructed. Certain structure has been, certain permanent structure has been built.
Lordship may specify 5 acres of land, my friend. Because they say 8 acres of land, but they claim that 5.22 acres have been acquired.
Acquired his land at measuring 5.22 decimal at Dharamgarh,
Dharamgarh, my lord.
Dharamgarh in the district of Kalahandi. Structures have been built. Stop. From the order sheet and the affidavits on record, it transpires that it was the specific case of the estate that the land in question was acquired under the provisions of Odisha Land Acquisition Act,
My lord, Land Acquisition Act 1894.
under Land Acquisition Act, comma, 1894. Stop. Despite several orders passed by this court, comma, the state, however, failed to produce section 4(1) notification in support of their stand that any land acquisition proceeding was initiated for acquisition of land in question. Stop. It further transpires that later on 31/2024, this court was informed, comma, based on instructions received from the concerned department of the concerned office of the state government, that the petitioner's land had not been acquired. Stop. You have not filed affidavit, though you are directed.
Lord, they have filed.
I filed the affidavit.
Not
Subsequent.
required.
Lord, not required.
Not acquired, it has been mentioned.
It was not acquired. But they have said that we are still searching. That could not be traced.
And affidavit has also been filed on behalf of the estate, from which it appears that the estate has no evidence of acquisition of the said land. Stop. Next, list this matter on 4 weeks. Stop. In the meanwhile, the state shall be at liberty to take a decision. In the meanwhile, the state shall be under obligation to inform this court about its future course of action in view of the admitted facts in respect of the petitioner's line in question. Yes.
Item number 24.
Wait, please, my lords. This, my lords, is a very voluminous brief, your lordship. A very voluminous brief, your lordship.
Of 2013.
Running around
I think,
676 pages.
Yes.
On our board.
Written notes also was submitted, I think, last year, when the last hearing had taken place. I'm not perfectly well today, your lordship, but I will be assisting your lordship by filing a latest written note with the update position of the workmen who are still concerned in this particular reference, your lordship. That will be easier for your lordship to dispose of the matter. Your lordship may give me some time, your lordship.
When do you want?
2 weeks, your lordship, 2 weeks.
As requested on behalf of the
When my learned friend is there.
as requested by the senior counsel representing the petitioners, more than one.
I'm for the union.
Petitioners list this matter on 2 weeks,
Your lordship may kindly fix it to 13th week commencing 13th any date, your lordship.
13th,
13th week commencing 13th, your lordship, any date.
14th, 14th. Yes.
Item
Out of the
20.
total workmen, your lordship, everything has been settled, your lordship, with the workmen. Only few workmen remain, and for a particular period, intervening period, for which this will be dependent on. That I will indicate to your lordship.
Item number 25.
25, my lord, on the last occasion, my learned senior took time to produce the rules relating which this entire rate appeal he's challenging, my lord. Yesterday was a holiday, so he needs more time to finalize the matter, my lord. We have already collected some documents, but those are not, it's not clear. So we have to type it again and we have to bring it to before lordship.
As requested on behalf of the appellant, list this matter on 1 week. Old matters.
Item number 26.
Much obliged.
26, Your Lordship, on behalf of Senior Counsel Mr. J.R. Dora. Your Lordship, the order number 12 dated 29/2024 may kindly be seen, Your Lordship.
All right, when do you want?
Your Lordship, on last occasion directed the state to give pensionary benefit, and accordingly we have already submitted pension paper, and I also given the pension documents to the learned counsel for the state, Your Lordship, my senior. But till date, Your Lordship, full pension is not given, Your Lordship. Copy. Affidavit copy not served, Your Lordship.
You have not received comments. When was that affidavit filed? When was that affidavit filed? It is not on board. It has not come to us.
Yes, what is your stand?
Well, he has not submitted certain documents for which pension has not been finalized. And we have requested him to submit all those documents so that pension can be finalized. That is the affidavit. And
Which document?
regarding that service book, everything is, I am see my affidavit. And second part, my lord, that on the last
After he files the pension papers,
there are wanting of some documents. Some that like the joint photographs. Those documents are to be submitted by that applicant. Your lordship directed me on two grounds. First ground, why he has not been paid salary for a certain period. Second ground, my lord, whether the pension paper has been finalized or not. You may draw my lord's notice for first order when this read petition was admitted, your lordship had directed him to grant that provisional pension. Accordingly, we have granted provisional pension. After my lord's order, we have directed him to submit all the pension papers. He has not submitted all the papers. So for that reason, we have not sanctioned. If he will cooperate with us so that we can grant pension, there is no problem to it. So far as that period is concerned, our specific stand is that he has not joined. So for that period, he is not entitled to the salary. My lord, may I preliminary lordship may hear this matter because what has happened? The tribunal, he has, after his reversion, he has approached the state administrative tribunal. State administrative tribunal rejected his prayer, dismissed the original application. So his reversion stands. After his reversion, he did not join because he was reverted. So till his retirement, he did not join, for which that period, 5 years period, has not been regularized. If my lord if your lordship will hold that tribunal order is wrong, then he may get the higher benefit. If your lordship will hold that tribunal order is right, my lord, then he will get the benefit at the scale applicable to the junior assistant. May I your lordship may hear this matter on merit. So far as pension is concerned, we are granting if he cooperates with us. And so far it relates to the post of junior assistant.
Your Lordship, if Your Lordship will permit me on the merits, I'll argue on the merits, Your Lordship. Your Lordship, kindly see Annexure 1, page 11, Your Lordship.
This is.
Annexure?
Annexure 1, page 11, Your Lordship. Lordship, the office of, may I please, Lordship? The office of arbitration tribunal of Bhubaneswar, Your Lordship, directed the employment officer for employment exchange for submission for giving names of candidates for the one post of LD assistant, Your Lordship. Accordingly, the employment exchange submitted names, that is at page 13. Petitioner place, find place of serial number 1.
Yes.
Your Lordship. Subsequently, Your Lordship, petitioner was appointed. When the petitioner was appointed, the arbitration tribunal was not the head of the department, Your Lordship. It became head of the department during the appointment of the petitioner. Before that, it was not. The OMS rule applies for persons selected under the head of department, Your Lordship. The rule they are talking about. Since during the recruitment of the petitioner, the arbitration tribunal was not the chairperson, head of the department. Thus, at page 27, annexure 7.
Department, head of the department is an office.
Your Lordship.
Post.
Your Lordship.
So the tribunal cannot be said to be head of the department or.
It became, Your Lordship. It became head of department, Your Lordship. That is there. They have also mentioned. Kindly see annexure 7, I'll read out. Annexure 7, page 27.
Yes, then.
May I read, Your Lordship? I am to say that the office of the arbitration tribunal was created under the INP department in the year 1978 without giving any definite status. The office has been functioning under the administrative control of the IP department. The chairman arbitration tribunal, Bhubaneswar, was declared the head of department in respect of establishment of.
This is what we are saying.
Your Lordship.
That chairman can be head of the department.
Your Lordship.
But not the tribunal.
Yes, Your Lordship. Under the chairman, the petitioner was appointed. Though any person was appointed under the chairman, for that OMS rule was required. But petitioner was recruited previously. They are the employment exchange. There is no mentioning of OMS rule, Your Lordship, because there was no advertisement for under OMS rule, and that's not applicable to the petitioner. And since that was not the case, Your Lordship, kindly see the very next paragraph. They have admitted and they have said how petitioner is to be regularized. That's what I'm submitting. One post of LD assistant along with some other posts were created for this office in IP department, so and so, and the post was filled up by direct recruitment in February 1980. Sri Jamini Mohanty, that is the petitioner, Your Lordship, a candidate sponsored by the Employment Exchange Bhubaneswar, was selected and appointed as LD assistant in the office of so and so. Lordship, kindly the next paragraph. Although passing the recruitment examination prescribed under the OMS Rule 1963 is a sine qua non for although recruitment of the post of LD assistant, now junior assistant, is the head of department, this fact was unfortunately overlooked. In the appointment order, this mandatory requirement should have been mentioned as the prime condition for his continuance and retention, and failure on his attempt to pass the recruitment examination would have rendered forfeit his service in this office. It appears that this office was in infancy. The codal provision recruitment rule has been lost sight of, which is a mistake.
The document which you are reading,
Your Lordship,
is not clear.
Lordship, then I'll submit a clear document. I'll submit a clear document, Your Lordship, if Your Lordship permits. But there they have.
Just read the fifth line, sixth line.
Fifth line.
Mentioned as the prime.
Your Lordship. In the appointment order, this mandatory requirement should have been mentioned as the prime condition for his continuance.
In our copy. Do you have?
No. While scanning, that page must have been.
No. It's missing. File it.
Your Lordship.
Press copy of annexure 7B file, which does not appear to be a complete document.
I have
by the petitioner.
I have served the copy of the affidavit.
Filed on behalf of the petitioner. By Thursday next. Yes. So this is on Thursday. Yes.
Item 27.
The petitioner here in blood challenges an order of cancellation of allot. The petitioner was allotted a property by IDCO. for establishment of a hotel, and that having been cancelled, that is the subject matter with your lordship. The cancellation order is annexure 12. Cancellation order is annexure 12 at page 64.
Yes.
Page 64, your lordship, kindly see. Cancellation of allotment. Please refer to this office letter dated so and so. This is the show cause notice in persons of which I gave so. Regarding breach of terms, the allotment of plots so and so made in your favor. We have received your reply in response to your above show cause notices. The reply is not satisfactory. You have violated the terms of allotment under so and so for plot number 6 in following grounds. This is the ground. You have not utilized the plot for the purpose for which it was allotted since long, thereby violating clause 16 of the allotment letter dated 23/4/19. This is the only ground on which the allotment was cancelled. Now, Lord, kindly see the allotment letter. The allotment letter is annexure 1, page 21. Page 21 is the allotment letter, and the clause 16 which they refer to is at page 23. Page 23, clause 16, you will have to start civil construction on the allotted plot within 6 months and utilize the plot and start commercial production within 2 years from taking over possession. This was the stipulation made in the
Clause, which clause?
clause 16, 1/6, page 23. Top.
Yes.
So this, they say, is the violation, that we have not constructed within 6 months of the. Lord, with this challenge, Lord, I would request your lordship to have a brief background of the case. I will place the brief background of the case. Allotment, as your lordship has seen, under annexure 1 is in 1999. There was a clause there, there is no doubt. But what had happened? There was an earlier cancellation of this allotment. This order was cancelled on 31/10/22. On 31/10/22, 2002. Sorry, 2002. Now, after cancellation, they initiated an eviction proceeding under the eviction unauthorized eviction act. In that proceeding, an order was passed. That your lordship may kindly turn to page 27. Page 27. The order I have given, annexure to page 27. Lordship says, I am placing the order. The case is taken up today. The representative of OP is present, has filed show cause. They have explained that super cyclone and they affected tourism industry, as a result of which they could not go ahead with the project. Now, as it appears, they have already started construction and construction materials have already been dumped on the field. In such view of the matter, the willingness and assurance that have been put forward by the representative of the OP, the court hereby directs Divisional Head IDCO to allow them to go ahead with construction work. Further, the OP is directed to clear the outstanding statutory dues within 15 days. Besides, OP is also directed to adhere to the terms and conditions agreed. So, a statutory order was passed permitting me to construct in presence of IDCO. On the basis of this order, I constructed the boundary line, boundary wall, and made some improvements on the land. Now, your lordship knows, for the construction, I need the building approval. Various statutory authorities' clearance are required. Now, I got the approval of BDA for construction on 11/8/2008. BDA granted approval of the building on 11/8/2008.
And when did you apply?
Lord, I applied, Lord, just 1 second. Page 30. Page 30 is the application. That is the date. 25/1/2010.
It was granted in 2000.
Oh, sorry. No, no. I'm sorry. 9/8/2004. 9/8/2004, drawing plans were submitted to ITCO for approval.
9/8/2004. Why 9/8/2004?
The order, after the order, constructed boundary wall and borewells were considered, then drawing plans were submitted on 9/8.
No, but immediately thereafter you could have submitted.
Pardon, sir?
Immediately soon after this
The orders were passed,
in
you could not
you could have taken.
steps for that. That is one. But that will not weigh before your lordship because of the subsequent fact. I'll come to it. Lord, now, admittedly, 11/8/2008, the BDA gave the approval. Lord, after BDA gave the approval, this is what I beg to submit before lordship.
Yeah.
Things were streamlined and they cancelled the revocation order. That order which was cancelled, they revoked the cancellation. So we came back to square one at that time. Then they executed the lease on 7/12/2000.
No, you did not come back to square one. Rather, the earlier your allotment was cancelled and subsequently that cancellation was revoked.
So we came back to the allotment
That stage.
allotment stage. And after allotment, lease deed was executed on 7/12/2010.
Yeah.
Now, the lease deed, now it would be one of my submissions for your lordship's consideration, subject to your lordship's consideration, that once the lease deed was executed, the impugned cancellation order speaks of clause 16. Clause 16 loses its existence. And I have addition to that effect also. Lord, the lease deed will come into force and it will be guided by the lease deed. Now, lease deed, your lordship may kindly see page 36. Lease deed is page 35. At page 36, your lordship may kindly see. 1 to 3rd paragraph. And whereas the lessor, lordship got, and whereas the lessor at his own expenses has developed and made them into suitable sites for putting up factory works, institutional buildings to carry on their industrial pursuits therein. Here it was admitted that some improvements and other things have been done by me. Now, the clause which I am speaking is at next page, page 37, clause 3. Clause 3A. The lessee shall have to start civil construction on the allotted property within 6 months from the date of possession and commence commercial production within 2 months from the state date. Lords, kindly mark, there is a striking difference between the two covenants. In the first allotment letter, which clause 16 I read, and this. He has to start civil construction within 6 months. Now, for civil construction, there was another clause in the lease deed which enabled like this, page 38, clause 5. Clause 5 says, notwithstanding anything contained in the lease deed, the lessee with the previous consent in writing of the lessor can assign or transfer his interest in the property in favor of any scheduled bank, financial institution, life insurance corporation, or any other bona fide source for securing loan to be advanced by them for purchase of machinery and new materials, etc. Provided further there, where the lessee for the purpose of constructing a building on the demised property seeks to obtain loan from the bank or other financial institution by mortgaging his leasehold interest on the demised property in favor of such bank or institution, permission of the lessor shall be deemed to have been given subject to the conditions. Subject to the conditions means this, that the mortgage shall not affect the rights that is there, that the lessor before exercising its rights and powers under this lease deed will consult the bank and financial institution as the case. That means a liberty was given to approach the bank for because I need finance from the bank and no objection certificate and to consult with the bank. To consult with the bank and get the loan. Now, after this, Lord, I approach the bank. Your Lordship may kindly see that.
Yes, please.
That is, kindly see Annexure 8 at page 55. So, I'm sorry, page 56.
Annexure 9.
Annexure 9.
No objection, sir.
No, we have received proposal from TK International petitioner for financing their hotel project, which is coming. I consulted the bank. The bank wrote to ITCO this way: is coming up on plot number so and so, has proposed to mortgage the land in said plot over which hotel, restaurant, and other infrastructure of the hotel be built. Our bank is processing the loan proposal for hotel project. In this connection, Punjab National Bank will require a no objection certificate from Orissa Industrial ITCO for mortgaging the land over which TK International will be constructing the hotel. They gave such a rider. Now, there was no adverse attitude from the side of ITCO against this. On the contrary, this what they did, they forwarded this letter. Lordship may see this. Paste it. That is page 59 and Annexure 10. On the caption subject, it is to intimate that above mentioned unit has applied for NOC to avail. This is ITCO writing to the bank. This is to ITCO to avail financial assistance from Punjab. The application of the unit along with other requisite documents are enclosed herewith for information and necessary action. Now, ITCO took this step and forwarded my documents for grant of no objection certificate. Your Lordship kindly marks, this is dated 15/5/2013. Annexure 10 is dated 15/5/2013. Now, on this letter, I had a legitimate expectation that my application, it's still, there was no refusal on their part. But within less than a month, they straight away went for cancellation.
So they must have given you a notice.
My lord. Yes, that's what I'm saying. Page 60, the next page is the notice. Next page is 21/6/2013. 21. They, on one hand, they have stated that they have forwarded my documents to the head office for grant of no objection certificate. I had a legitimate expectation that it will come. If it would have been rejected, then the things would have been different. But without giving any reply, they straight away go for cancellation within 15-20 days of this letter.
So where is this clause 716?
Pardon me?
Where is the clause 16?
16, I read of page 21 in the allotment. 23. Page 23 is the relevant. Page 23 is clause 16. You'll have to start civil construction on the allotted plot within 6 months and utilize the plot and start commercial production within 2 years. But thereafter, much things have happened. Cancellation was effected, order was passed, and thereafter cancellation was revoked. I applied for the bank. You could have straight away stated that way that no, we cannot give you that no objection certificate. You go on with us. Now, after hearing my lords in this case, the petitioner, your lordship passed an order. Lordship, 19-123. Lordship, I'll place that order. Lordship, kindly see that order. 19-123. After hearing both parties, this honorable court passed an order. I'm placing that order. It is seen that amongst other grounds, the petitioner contends that it was not in a position to complete civil construction and start commercial production on the plot in question without NOC from IDCO. In paragraphs 9 to 11 of the writ petition, averments have been made in this regard, which have not been replied to at all by IDCO in its counter affidavit. There is only one line in paragraph 12 of the counter affidavit which tries to deal with 9 to 11 together without dealing with the averments there. Learned counsel appearing for the IDCO seeks leave to file a supplementary counter affidavit specifically dealing with the averments made in the above 9 petition. The said affidavit be filed with it. In pursuance of this order, they filed an affidavit. Lordship, I kindly see that affidavit. This affidavit does not disclose why NOC was not given or why, because the order specifically says that because NOC was not, my contention is because NOC was not given, I could not proceed with the construction. The order also reflects that. But in the counter, rather an affidavit in pursuance of this order, that your lordship may see that has been filed on page 96. Page 96 of the brief.
Yes.
Paragraph 3, that in reply to the averments made in paragraphs 9 to 9.4, it is submitted that on 29/4/11, the plan of the petitioner was approved by the Bhubaneswar Development Authority, but thereafter the petitioner did not proceed to start any construction, which is nothing but violation clause 3 of the lease deed by annexure 6, which is specifically stated that lessee have to start civil construction on the allotted property within 6 months from the date of possession. In this paragraph, the petitioner has admitted that it got a techno-physical report on 3/9/2012. Be it noted that techno-physical report by NID is a report by a private consultant hired by the petitioner, which is submitted almost 1 year from the date of getting. My humble submission is, your lordship's specific query was on the question of NOC. They received my motion for grant of NOC, forwarded the documents for necessary orders, but without waiting for any result, within 15 days they cancelled it. That was your lordship's specific query in this. That has not been answered. But then another date, the matter was taken up. But I even offered that in the present market value, I can take it. Because I have spent huge amounts and invested everything and on your and court's order also. That also they file an affidavit that they cancel. They are not willing. But the question here now boils down to this. Grant of NOC, I need finance from the bank. There is a clause in the lease deed that you can get finance by mortgaging the property. It's not out of the lease deed. And accordingly, I submitted my documents. There was no response from your side. You could have rejected, then I would have thanked my fate and gone for it. But without waiting for any outcome of that, straight away go for cancellation. That's good.
I am there for opposite part number 2 and 3, my lord. I am there for opposite part number 2 and 3.
Yes.
Lord, prior to the present cancellation, my lord, when the previous
the submission which has been advanced is that anything before the lease agreement was executed becomes insignificant. All right. So you, according to him, whatever is to be done in the light of the lease agreement.
Lease agreement, madam. Well, prior to the present cancellation, madam, when the prior cancellation was revoked, it was revoked under certain terms and conditions. My lords, may kindly see page 34, my lord, and next year 5.
No, when was that revoked?
13/9/2010.
And when was the lease agreement entered into?
Subsequent to that.
So why did you enter into lease agreement?
My lord, I will come into that, madam. Just, my lords, may kindly see page 34, madam. In pursuance with Estate Court Order dated 38/2010, communicated to this office by memo number so and so, we hereby revoke the cancellation of allotment issued by BCD 1, letter number so and so, subject to the following terms and conditions. 1. That the allotted property should be utilized for the purpose for which it is allotted within 1 year from the date of revocation of cancellation of allotment. To this effect, you will have to submit an undertaking in non-judicial stamp paper indicating the detailed time about the implementation of the project. Now, 2. That failure to implement the project within a period of 1 year, IDCO shall be free to take action against you as deemed proper, including reimpose of cancellation as per the above undertaking. Now, after that, the lease deed was executed, madam. Now, the lease deed is nothing but an addendum to this document, madam, and to the main allotment letter, madam.
No, but the question is that these were the conditions.
Madam.
These conditions were put in 2010. The lease agreement was entered into in 2013.
No, my lord. 10.
7/12?
2010.
7/12/2010. Yes, 7/12/2010. Yes.
My lord, even if we consider the lease agreement, my lord, as per clause 3, the lessee shall have to start civil construction on the allotted property within 6 months from the date of possession and commence commercial production within 2 years, my lord. Now your lordship may see page 53, my lord. Sorry, page 52. Page 52, annexure 7/1 is the document where BDA granted clearance to them to go ahead with the construction. After that, and this document is, my lord, dated 15/10/2011. After that, my lord, they waited till September 3, 2012 to obtain a techno-economic viability report. And this report, my lord, is obtained from a private organization. Here they were not stopped, my lord, to proceed with the construction, my lord. Thereafter,
No,
my lords may
but it is their submission that they could not have proceeded with the construction because they did not have the fund.
No, the question of funds that comes into play, my lord, on 10/1/2013, my lord. From 15/10/2011 till 10/1/2013, they were doing nothing, my lord.
From 10/11?
From 15/10/2011 till 10/1/2013, my lord.
They didn't do anything.
My lord.
Huh?
they just obtained one techno-economic viability report from a private organization. And we are no way concerned with that. They ought to have obtained this report before the planning of the project, my lord. They waited more than 14 months, my lord. Thereafter, they applied to us for a no objection certificate. And basing upon that, a show cause was issued, and after hearing them, the allotment was cancelled.
You intended to cite some judgment or?
Lord, your lordship, it came out from your lordship's mouth also that judgment. That is reported in AIR 2018 Supreme Court 1981. AIR 2018 Supreme Court 1981. I have downloaded it from there. But this is in the instant case, before your lordship goes to that decision, in the instant case, what had happened, similar case was there. There was an allotment order. And allotment order, that same type of clause was there, you have to complete. And the allegation was you have not completed. Now, subsequently, sale deeds were executed. In our case, lease deeds, but in the reported case, there were sale deeds were executed. Their lordship says that once sale deed was executed, the stipulations in the sale deed have to be followed, and there is no similar clause there in this sale deed. To that extent only, that sale deed.
Sale deed is different.
Lease deed, this is also lease deed transferring a right. Your lordship knows that this is also, the only difference is there it was a sale deed, but to this extent I rely that what I beg to say, that all those conditions, even that the order, cancellation order which my learned friend placed, after that the lease deed has been executed. So we have to follow from the lease deed.
No, sale deed cannot be conditional.
Pardon me?
Sale deed cannot be conditional.
No.
And therefore, in that background, the Supreme Court must have held.
Maybe to that extent only I rely. That's it. But that is at page 18, paragraph 18.
So therefore, this decision will have no application.
To this extent only I rely on. To that extent only that the subsequent document will prevail. That's so. In my case also I say, my learned friend placed the revocation of allotment order, but subsequent to it, the lease deed was executed. So we have to go from the lease deed, and lease deed contains a provision for what my learned friend says we waited for 2 years. I got the techno-feasibility report, and thereafter he says it's a private document. It was in their domain to reject it, saying that we don't accept it or something. They did not inform anything. They accepted the report. The report, after getting the report, I applied for loan, because that was the time when I could construct. I need money. And one thing sorry for repeating, but one thing I beg to bring to your lordship's notice again, that yes, they could have rejected it then and there. No OSO is required. But on the other hand, they forwarded my request for processing. And on the other hand, they issue cancellation within 15 days. Yeah, that's all.
If I may, my lord.
Order.
Even
it will come on Monday again. In the meanwhile, we will examine this case on Monday. In the meanwhile, if you can give us list of dates, have you given?
I have given that. All the dates which I have mentioned, I have given that in my list of dates. ठीक है, देखिए देवे अच्छी अच्छी oblige.
my lord, we have prepared a list of dates. I'm just filing.
Item 28.
The petitioner is a workman who challenged the termination before the labor court, and award of reinstatement was passed. Thereafter, the management challenged the same before this honorable court. The award of reinstatement was confirmed. Thereafter, writ appeal filed, that was also dismissed. The petitioner all through sought to join the establishment by filing the joining report himself and by the through the labor authorities, but that was not accepted by the management. And thereafter, the petitioner filed a petition under section 33C2 for computation of the benefit of the reinstatement. In the
Then what happened?
in that petition, my lord, after the complainant, after the petitioner, the workman was examined. The opposite party management filed a petition to summon an witness to prove the gainful employment of the workman. That was objected to by the workman on two grounds: that it is beyond pleadings, and so far as computation of the benefit is concerned under 33C2 proceeding.
No. Beyond pleadings means who?
Because
You had to establish that you are not in gainful you are not in any gainful employment.
Here it is in the 33C2. Award of reinstatement already passed, confirmed by award of reinstatement already passed by the competent court, confirmed by this honorable court. So question of reinstatement is already, entitlement of reinstatement has already there. Now the under 33C2, the settled law, my lord, knows that the labor court cannot go into the question of entitlement. The only question is to compute the benefit. (33C) 2, my lord. Where when a workman is entitled to receive from the employer any money or any benefit which is capable of being computed in terms of money, and if any question arises as to the amount of money due or as to the amount at which such benefit should be computed, then the question may, subject to any rules that may be made under this act, be decided by such labor court as may be specified in this behalf by the appropriate government within a period not exceeding 3 months.
So you met this application.
Yes, madam.
Then what happened?
Then after examination of the workman, the management filed a petition to summon an witness to prove the gainful employment of
What is wrong in that?
Madam, I objected to that on two grounds. One is this is beyond pleadings because the management has never.
How can you say that? This was your application. You had to plead.
My application is to compute the benefit.
Mr. Counsel, while making that application, you were required to say that during this period I was not gainfully employed. Did you say that?
My humble submission is that in the 33, since only the computation of the entitlement is
That is a relevant factor, Mr. Counsel.
My humble submission is that is not a relevant factor. That is my
That is
not a relevant factor because
not a relevant factor.
that is my submission, my lord.
We reject.
My lord. Only why I am saying, my lord, because the settled law, my lord, in this regard is.
Where is that settled law we will follow?
My lord.
If the law is so settled, then we will follow that.
My lord,
where is that settled law?
I understand, my lord. My lord, my submission, why I am making this submission with my lord, because if while calculating or computing the benefit of reinstatement, if the court came to a finding that yes, I am in gainful employment, I am in gainful.
Court will come to a finding. How will the court come to a finding?
Because the management is.
Management doesn't know.
No, here, my lord, management was allowed to lead evidence.
Mr. allowed to lead evidence because management might have taken a plea that he was, according to you,
They have
there
not-
was no.
They have
there was-
not taken the plea, but allowed to take the evidence.
Yes.
Now, my lord, if that, what is the purpose of that evidence, my lord? The purpose of the evidence is to prove my gainful employment. Let us, that is proved. Then what will happen, my lord? The benefit of reinstatement, either the benefit will be taken away
No,
or that portion of the amount will be reduced.
yes,
My lord, then my humble submission is the benefit of reinstatement which I am entitled to, that cannot be reviewed by the under section 33C.
very difficult. Both, the two things are different.
Because that will amount to rewrite the award. That is my whole submission, my lord.
Rewrite the award.
That is my whole submission, my lord.
Submission, then submission.
My lord, that is the only submission, nothing else.
Yes, sir. Any doubt? Huh? That is.
Because
And
miles have already.
one more thing, in that petition, I have objected that the relevancy may be decided at that stage. But labor court said that I will decide it at the time of final hearing. That is one aspect.
My humble submission, my lord.
This is premature, Mr.
Because as per
This
136 of,
petition is premature.
as per the 136 Evidence Act, while allowing any party to lead evidence, the relevancy has to be taken into account at that stage.
So relevancy is patent. The relevancy is manifest.
If my lord holds that it is relevant, then I have nothing, my lord. But my
If
submission.
the old relevant, then your entire case goes. What do you want? At least the court is taking into account whatever submissions you have made. Otherwise, from this court, you will have the finding. What do you propose?
I have,
Any?
my lord, I have some decisions, my lord. Of course, it is.
All right.
May I place one decision, my
Would you
lord?
pursue still? Would you pursue still?
One decision I am relying on, my lord. One.
Please, please.
It may not be applicable fully.
If you can rely on a decision which does not support your case, there is
There
no
is-
problem. But you please don't rely on a case which demolishes your case.
No. Why I am saying so, my lord? What that decision says that if the very language of that decision is that the proposition is well settled that the labor court computing in terms of money, the benefits of an award in favor of the workman has got only the role of an executing court, and it cannot reopen questions which must be deemed to have been concluded by the award passed earlier in the favor of the workman. The question as to whether the workman was employed elsewhere, earning wages, and hence he is not entitled to back wages and other attendant benefits ought to have been put in issue during the course of the adjudication of the industrial dispute. And when such an issue was not raised at all by the employer in the instant case, the second respondent covering adjudication over the same by the labor court, it must be held that no such issue appropriately and genuinely arose requiring adjudication of the same by the labor court, and the award passed by the labor court must be taken to be the final adjudication of the entire controversy over the non-employment and the reliefs to be accorded to the workman. The labor court, as the executing court, cannot go behind the award, nor can it subtract from it. It is not certainly open to the labor court exercising powers under section 33C2 of the Act to go into this question and practically negate what has been given by the award to the workmen earlier in the industrial dispute. That is exactly what has happened. That is but this decision is of a single bench of single judge
No,
bench
but
of,
where is the award?
my lord, award is for reinstatement.
No, but Labor court has not finally declined your claim. The matter is still pending.
But my lord,
Let the labor court decide. We find some force in your submission, but still, since the
My-
matter is pending,
my lord,
let the labor court
with
decide.
that observation, I'll kindly be disposed.
We run counsel for the petitioner after some argument seeks permission to withdraw this application with the liberty to pursue the issue raised in the present proceeding before the labor court, and particularly the issue that the employer cannot take the plea of the fact that the workman was gainfully employed during the period of termination of his service.
Well, it's not during period of the termination, what my lord. After there is an order of reinstatement. He claims the benefit honored from the date of the reinstatement till date. That is what is his claim.
Termination?
The award is to reinstate. No arrear backwages and all these things. What he claims is that the entitlement honored from that date because of the reinstatement has not been extended to him.
That from the date of the award, of course.
Probably minus 33
Because
C2 minus is not a minus remedy in this respect. Minus, that is the rudiment concept what we learned.
To pursue the issue before the labor court.
In a
Where
33
the matter
C2
is still pending.
in a 33 C2 posting.
Yes.
In a 33 C2 posting, my specification.
33 proceeding. So the sentence for taken. And for the petitioner after some argument seeks permission to withdraw this petition with the liberty to pursue the issues raised in the present writ application before the labor court in a proceeding under section 33C of the industrial dispute.
That they raised that, my lords. That they raised. But the learned labor court said, all right, will consider all those things, let him be examined.
That the labor court will.
Already labor court passed an order that will examine it, but let there be examination of the employer,
Yes, yes.
where he has been duly employed.
So the labor court has not decided.
No, labor court only said that we let him come, let there be evidences, thereafter we'll take a decision, final decision.
Yes.
Item number 29.
In item 29, your lordship directed the matter to be placed before the conciliation cell. And both parties appeared before the mediation proceeding. And the date, the last order is like, and matter is pending before. This order has also been communicated to this honorable court, which is at flag B.
Mediation rules है. Mediation rules.
Flag P.
Please read rule 18 of the mediation rules. Page 171. And this is not the way the mediation proceedings are held.
Time limit is prescribed 60 days from the date fixed for the first effect.
He is deciding it like a suit.
Yes.
It's a different process, proceeding altogether.
Government has,
Government has-
Where is the question of filing written submission and this thing?
My lord, of course, not written in the order. What I got instruction from the director that to settle this dispute, they have to forego certain revenue. And for that purpose, they have to place it before the cabinet and cabinet has to approve it. Because a huge amount has to be exonerated. So now due to this election, there is no, it has to be again after the election and new government comes, then it has to be placed before the cabinet for approval.
Still, the mediator should
Yes,
have.
this order is this is the instruction which I have received that for this purpose.
No, that is different matter.
Yes, my lord. Yes, my
The
lord. But the
mediator,
order is.
the mediator could not have adjourned the matter to 9/7/2024, 3 months after this. Not the way. We have perused the notings of learned mediator dated 2/4/2024, whereby he has directed he has adjourned the mediation proceeding to 9/7/2024. Stop. It appears that the mediator is not aware of Rule 18 of the mediation so-and-so rules.
Mediation rules 2000, the civil procedure mediation rules 2007.
Stop. At the rule which reads as under. Stop. However, in the interest of justice, we extend the time limit for completion of mediation by two 7/2024. Stop. The parties shall be required to appear before the learned mediator with the present order on Tuesday. Please let him know.
Yes, yes.
He may fix any date, whatever in the meanwhile, but mediation is a different process altogether.
Will appear on Tuesday or Wednesday, whenever your lordship.
He cannot understand. He has no idea about the process. Yeah. T7, consonant, T7.
4-7.
4-7. In the meanwhile, take a decision.
Yes, ma'am.
Right, resolve it.
Yes.
Let us have some respect for the statutory provisions.
Yes. Actually, this is the direction of the Honorable Supreme Court that this matter may be placed before the Constitution.
Therefore, there is direction of the
But
Supreme.
I got the instruction, it may happen, but subject to approval of the cabinet. So for that purpose.
You're right.
Yes.
You're right. Even this decision could have been taken in the mediation process. Someone is not required to file written submission, and
No, that is for
the dispute is not to be resolved by the mediator. All right. The mediator's role is to create a situation when the parties themselves arrive at some solution.
Yes.
They offer solution. The mediator does not do anything. Just he exercises he applies the techniques.
That is why perhaps Rule 12 is very clear.
Yes. The role of the mediator.
No, not to be guided by
CPC or Evidence Act. That is there. He is not to be guided by.
Even the records are not to be seen by the mediator. Not required.
Loco parentis.
I will personally
Yes.
look into it and ensure that something is done.
Item number 30.
Lord, wait, please, Your Lordship. Lord, I have given a date chart. I think whether it is available on record, I don't know. A date chart was given.
Yes.
If it is there on
It is
record.
not there. Not. You have one. Extra copy you don't have.
Sorry.
All right. What is the matter about?
Yes, matter
If the
actually.
matter is simple, then we can take up otherwise.
There is a small point involved, in fact. But a society was constituted. Society formed a college, junior college, Ballot. The
Which
college was college Ballot, establishment of a college. College applied for permission way back in 1985. The date is 18/9/1985. But Section 5 of the Act says, when
Which
the permission, Section 5 of the Education Act, it says when a permission is applied, then they have to make an inquiry whether the criteria which has been fixed, whether it is satisfied or not for granting the permission. After the permission is obtained, then question of recognition comes on Section 6 of the Act. After the recognition was given, thereafter the governing body is formed and the college is to run as per the provision of law. But here, in fact, application was filed in 85. Direction was given that a principal of Bhadrak College is to go and inspect. He did not visit. Subsequently, again, reminder was given. But because at the time when the establishment of the college was there, employees were recruited, the staff, everything was there, but they have to come and visit and find out whether the staff is all right or not. So eventually, in 1990, again, another request was sent by the government, fixing a date for inquiry. That inspection was also not undertaken. In 99, the inquiry was conducted. It was found that yes, I satisfied all the basic ingredients. But recognition was given from 2001 and 2002. All these years, what happened? In the practice was at the time, you take students, undertake the study, but since you are not recognized, they cannot actually appear in the examination in your college. I have to apply for the authority. They have to direct me that they should be appearing examination in another college. So that is
was
how
an illegal practice, Mr. Mishra.
So that was going on, in fact, because the recognition was delayed.
Illegality cannot be, in fact.
Yeah, I vowed on that. That's what I say, Maran. It's not correct, but that has been done. Now, it is not for the students alone. The employees who were appointed, if the inquiry could have been done much before, it could have been satisfied all the ingredients. So only recognition is to be given from the date effectively from which actually it has been done. That's the only point involved. But what happened, the Honorable High Court, in an earlier writ application, directed to make an inquiry and find out whether actually they have to be recognized prior to the date when they have done it. But that has not been carried out.
Nothing can be done. You could not have admitted students.
Sir, they have already appeared and they have gone, my lord. That chapter is over. The only question is, staff was there.
But how retrospective recognition or affiliation can be?
But they delayed. They themselves in the counter, they said they have delayed.
They might have delayed.
Because of their delay.
In one of the judgments rendered, I have rendered the judgment in Patna High Court that this is impermissible, and
Supreme Court also deprecated. Supreme Court also deprecated. You cannot admit
all those admissions
right
in such colleges where the recognition was not granted, affiliation not given, those admissions were illegal. There is no question of in the absence of the I don't know the provision here, but in that case I have held that in the absence of affiliation, no institution can admit students.
No, your is correct. No, nobody can be admitted, but it has happened and it has happened. It has
happened. It has wrongly happened.
But the question here actually short point is, but once the direction was given to make an inquiry, they did not do it.
They did not do it, then you did not do it. You could have come to the High Court. Let's see, this is what they're doing.
We approached, Malad. We approached. If you also kindly see that.
In no case, retrospective recognition or affiliation cannot be directed to be granted. And they cannot be allowed to do it. We are putting it differently. There is no question of direction. The court will not allow them to do it.
I understand already. The Honorable Single Judge, if you also kindly see the order.
Difficult, Mr. Mishra.
Single Judge said there is no dispute to the extent that the permission has been accorded to for the session 2002-3, but the petitioner pursued his grievance that the institution should be granted permission with retrospective effect, that is from 85-86, but No material has been produced before the court to that extent.
Page 30, if your lordship turns, my lord, page 30.
Same view has been taken.
Page 30 is the letter dated 8/1/1986. Annexure 3 is the Director of Higher Education. He says, I am directed to request you to kindly furnish the report on the following points for taking further action in the matter, whether the secure deposit, that is one part of it, whether the college possesses 10 acres of registered land, whether the student strength is 70, whether all the qualified teachers have been appointed having 54% mark in their credit at PG stage. They have to be recruited before that, actually. Unless they recruit.
Right. You have to establish, you have to have a building, you have
Yes.
to recruit teachers.
So that
You
is
have to
exactly
recruit class 4,
no,
class
that is
3
exactly my
employees.
point. They have been recruited. The building was there.
Yes.
10 acres of land was there.
Then you have to satisfy that now I fulfill all the conditions. Please grant me recognition and then affiliation from the university.
Well, it was
That is the law.
available since 1985. It was available since 1985. Those persons who were recruited.
What is happening in Odisha has happened almost everywhere.
Yes, sir, practically everywhere. That's right.
Illegally.
If your lordship kindly turn to the next document, Annexure 4.
Sorry, Mr. Mishra. Not a case.
That one order, if your lordship kindly see before your lordship passes an order, page 39, my lord.
Yes.
This was on 2003 order. The operative portion, if your lordship looks at, considering the above facts and circumstances, simple grievance of the petitioner was to quash the order dated 19/4/2001 and directed to Annexure 8. We further direct the petitioner to file appeal for the authority. If the appeal is filed by the petitioner before the opposite part number 1, who shall be considered the appeal as per rule and prior educational amendment to 1989, pass order granting concurrence permission from the academic session 85-86 within a period of 4 months.
Yes.
Because all those documents were also presented before the High Court also. But they have not done it in spite of such a direction.
Nothing can.
And they delayed the matter. 2015-16, actually, they delayed and took
They can do
10,
that.
15 years time.
They can, and that was the reason. That was the reason why in Bihar, I had fixed the time limit when the state government shall have to take a decision.
Right, right.
So this happens everywhere. The matters remain pending for 2 years, 3 years, 4 years.
But in spite of direction.
And in the meanwhile, the institutions kept on admitting students, which was deprecated.
Page 50, if you're also going to see one more document. Page
Every
50.
page we are ready to see.
Page 50, Kavalanga College. Pursuant to the order of the High Court, permission and recognition to clause 2 arts with 64 seat per section 84-85 is considered. Rejected at the same is devoid of any merits since the students admitted the college did not actually appear in the annual CS examination. That's the only ground on which students didn't appear. They accept that it is there.
They accept.
The students cannot appear, in fact. Your lordship is right, they cannot be admitted also.
They should not have been admitted.
Yes. Students have, well, that is, we accept that proposition. Only proposition is, since we have established and requested that you verify, you took till 1999, 2000. That's the only points there.
So you can, if you can give your list of dates.
I'll give, can it be on Monday? I'll give it so that
Okay.
your worship can pass it. It is there with me. I'll give you extra copy.
Item 31.
The sole issue in this case is, madam, whether the revised scale of pay is applicable to the employees of the corporation or not. madam. Employees of the State Transport Corporation. The appellant is State Transport Corporation. madam. The issue is, madam, whether the state revised scale of pay applicable to state government employees or applicable to the employees of the corporation. And the learned single judge allowed the application, and we have challenged the same. And your lordship, last occasion, 6/2/2024, my lord, the only ground we have challenged that we have no sufficient fund to give them that revised scale of payment.
So there are two aspects,
My lord.
legal and your capability.
Yes, ma'am.
So if you are under legal obligation
My lord.
to adopt that pay scale, then you cannot take this plea of insufficiency of fund.
What happens, my lord, in this case, my lord, there are two set of employees in the Odisha State Transport Corporation. Once employees who are elsewhere in the state transport service come to the corporation and they are working there. So during the pendency of this application, my lord, state government has allowed the scale of pay that those employees who are come from STA, that State Transport Service, to the corporation, are eligible to get the revised scale of pay
Rightly.
and granted them. But so far as corporation employees concerned, there is no grant, my lord. So we are not able to pay, my lord. For that reason, my lord, your lordship has.
No, why, where is the decision? Why, on what reasoning the learned single judge directed?
My lord, before going to that, my lord.
Because suppose,
My lord.
see, those employees who had come from the state government to the corporation,
My lord.
they would be entitled to the scale which they were getting.
Yes, sir.
And which employees of the state government would be getting.
My lord.
But those employees who were engaged by the corporation, they possibly may not claim the same salary which
That is our plea in the before the learned single judge, my lord.
So
And also,
what reasoning has been assigned?
reason has, my lord, assigned that since it is a, my lord, corporation and governed by the transport rules, my lord. So, my lord, corporation has to give the that pay as per the state government, my lord.
Let us see the order.
My lord. And for that reason, before lordship, my lord, before going to that order, my lord, on 6/2/2024, my lord, this honorable court was pleased to direct the state government, my lord, to take instruction about releasing of fund, my lord. Your lordship can have grants.
No, forget fund. Let us first come on the law.
My lord.
Para 29 of that judgment.
Where is that? Where is that judgment?
That is para 29 at page 25 of the impugned judgment.
Page
25 of the impugned judgment and para 29.
29.
Impugned judgment is at which page?
My lord, at page 16, my lord. Starting relevant page, starting from 18.
Para 29 after 4 line, only plea has been taken. This was the
internal page 25 of the judgment, my lord, at para 29.
What is ORSP rules?
Odisha state revised scale of pay.
How these rules apply in case of the
My
employees
lord.
of the corporation?
If your lordship kind of glance to paragraph 17, page 28. Lordship got it. Paragraph 17 of the impugned order. Lordship got it.
So this is your decision.
Yes, my lord. That is it prospectively, my lord. They are claiming that the revised scale of pay will be applicable since 1998, my lord. We are, my lord, decided to pay the revised scale of pay 98 since 16 to 2019, prospectively, my lord. It is our decision. They have challenged that it will from 1998, my lord.
So what is there in paragraph 18? So earlier there was any decision of this court.
Since the rules is effective till the return of petition. That is in relating to, my lord, state government employees, man. Not for the corporation, man.
Let's come to this paragraph 12 at page 14.
My lord.
Notwithstanding anything containing these rules, the areas dues to which government servant is entitled. This is regarding government servants.
My lord.
Come to paragraph 18.
My lord. Since the court has already taken a view that ORSP rules, my lord, 90 is effective from 1196 till the retirement of the petitioner, either under the VRS or attaining the age of superannuation. No other alter view is permissible in this batch of cases who are on similar footing.
So it was already decided.
No, my lord, that is not, my lord, wrong, my lord. So far as this proposition of law is, my lord, for corporation employee, it was from 90. It was to be affected, my lord, since 16 to 2009, my lord, not from 98, my lord.
Yes, Mr. How is this?
ORSP rules 98 came into effect from 1196.
Please.
The corporation did not accept at that time. It was
Did not?
The corporation did not accept at that time. It was accepted in 2009 and with prospectively. That was under challenge by both the sets of employees. As my lord and friends have already figured out, two sets of employees were there, one from the SPS and from the direct recruiting. So they are remain in a common cadre, same scale of pay and same duties, and prior to that, all other pay fixation both have got the same benefit. All the ORSP rules prior to these rules 2009 came into effect. That all the
Mr. Please come to paragraph 18 and
Yes,
clarify
yes,
whether before this paragraph 18 there was any decision of the court that they shall be entitled to this salary with effect from 1/1/1996. since this court has already taken a view, where is that view?
Oh. वही लेता हूँ इसके मिशन करता हूँ
Don't prepare in the court.
I'm done. Okay.
Tomorrow.
Tomorrow.
Item number 32.
Yes.
Sorry.
कौन सा item है ये?
31.
Judgment of 12/3/2018.
Yes, ma'am.
Judgment of 12/12/2018. Or 17.
Next week बताओ.
Yes, so this was decided already in 2017.
Well, that Mohindra Mahanti case, madam.
Yes, sir.
Yes.
Well, that's he has came to OSRTC on deputation, madam.
Huh?
He is a STA employee.
Mr. Patel, what is submitting is correct?
No.
Madam, that WPC number
Yes, please come to paragraph 3.
20784 of 2014. Your Lordship is Mahendra Nadi State Transport Corporation. STS employee. STS employee.
Huh?
He is an STS employee.
No,
STA.
STS. State
STS.
Transport Service. Mahendra Mahanti.
STS employee.
He is my
He is a STS employee.
Huh?
But that he is also from the state service, state
Oh.
transport service. That Mohindra Mahanti.
Then?
What
Please.
happened, your Lordship, the main ground of one point, your Lordship, may kindly have glance to para 25, 29. What are the ground of the corporation? That is financial crisis. That due to financial crisis, we are unable to give the arrear salaries. That is the only ground that your Lordship will give. From the para 29 of the judgment, that is at page 25 of the full judgment. Lordship got it? Just I am preaching, madam. May I place my lord? After 4 lines, only plea has been taken by Mr. Mahathir on a senior advocate for the corporation that the financial condition of the corporation is not good to sanction such arrear salary. There is no proof filed by the corporation as to financial condition of the corporation.
Mr. Please show us from this decision that it was rendered because they were STS employees.
I will show, man.
Show it.
Madam, I have not gone through.
You have not gone through this decision.
What from my debt chart, my lord.
Huh?
My debt chart, my lord. I have written that he was
So
the.
your debt chart is not a judgment,
No,
Mr. Counsel.
Not only not. But my humble submission, my lord, he is coming from the STS employee. For the STS employee, state government has decided to give them.
Whether there is anything in that decision that because they were STS employees, they were entitled to salary with effect from 1/1/1996. Is there any finding? Is there any logic reasoning given?
No, may I pray, my lord? Let it come next week. I will verify and.
Not next week, tomorrow.
My
Note 32.
May I pray, my lord, for a copy of that.
Of the judgment you want.
That Mahendra.
Is this judgment you want? We will direct that you will not get. What is this?
Mr. Patra, don't you have extra copies?
No, he has no copy.
You are
of
lying
that
on the
He has no copy.
decision and you
I will give another.
not supply. Supply so that he will get ready and come.
Your losses has directed, your losses have directed the state council to file an affidavit. Copy.
Your Lordship, on last occasion, I directed me to file an affidavit. I want 1 day more time. I will file affidavit by tomorrow.
Yes, my lord,
That's my, may I pray, madam, it may come on Monday.
Monday, my lord, I will not be available. Monday, I will not be available.
On Thursday?
I will go out.
Thursday.
Okay.
On Thursday. So as to enable AGA to comply with the order dated 3/4/2024.
Item 33.
Which was part 33, Lordship, kindly come to the WPC 34769 of 2020. That was the lead case. I'm ready to argue the matter provided my non-friend will cooperate. Today it cannot be finished. Or Lordship fix up any time at 2 o'clock. So that I was told that if I'll have a
time to give the brief, Lordship.
How many cases are there?
that is
One case which I have filed, Lordship. This is sub item 1. If it is
about
taken, all my cases will be covered. Item
but
33.
these are cases where the virus of 2004 granted are the subject matter of challenge. And in fact, this WPC 34769 was heard by a division bench by your Lordship's predecessor. And on 17/8/2023, Lordship said that this WPC 34769 of 2020 was the lead case. There I have given the date chart. I have also prepared another one and also note of submissions. And while the matter was argued at length, of course, it could not be finished.
Happens.
So about 70-80 matters exactly in the list. So if your Lordship will take up one matter, that will, I think, cover up all the cases.
My matter, Lordship, is slightly different.
Tomorrow.
My matter is slightly different.
25th we can take up.
Yes, Lord, at 2 o'clock. Lordship, kindly fix up 2 o'clock.
Yes.
Tomorrow, ma'am.
25th at 2 o'clock.
Sir, it is always better to decide the cases in the courtroom.
Sure.
Because if the judgment is dictated in your presence, it becomes easier for. So
But
let
there are
us try.
some types of cases where your lordship is bound to keep it that just because.
No,
Uh,
that is because of the time constraint.
Right. But in many matters, your lordship can deliver.
Instead, what my lord is saying, instead of taking 2 o'clock, it will be.
It should be taken up at 10:30.
No. Lordship, it happens to dictate in the court.
Let us try. So if you decide to finish it within 1 hour, just refer to the. If everyone finishes within 1 hour, then it will take 70, 80 hours. No.
That's it. I promise within 2 hours.
Therefore, if all of you decide and complete the submissions within 1 hour, we can dictate the judgment in the court.
It's better if you get ready with the short note.
No, I have prepared.
in your
I have
hand,
prepared.
Then time constraint will be streamlined.
It's a pure
So that
question
we
of
can-
law, of course, but
Basing on your
yes.
short note, we can. What my learned friend says, it's pure question of law, short note will be available, my lord.
Okay.
Item number 34.
This we can do. When
May I plead your
in such cases, we have which we have.
Dated 22/3/2023, your lordship. 34.
Just a minute.
Complete.
I find a complaint of 59/2023 saying that we are compliant with orders, we have found out 19% to be eligible for that benefit on the guarantee. 6 people are not eligible and we are sanctioning 8 lakhs in some order. To that they have objected. I find their document saying that we will not receive that amount because this content is pending. Now to that compliance affidavit, my friend has filed an objection saying that this court has gone to the finding that we cannot reopen the issue and we cannot identify the enough beneficiaries and we have to benefit all. To that I object. My friend has got to say you can also kind of improve.
I'm sorry, sir.
Not implemented.
I'm sorry to interrupt your lordship. This court has come to a conclusion. The petitioners are under displaced category. What they have sanctioned, your lordship, they have sanctioned under the affected category, which is much less than the displaced category amount, your lordship. That's why, your lordship, we have objected there because they were treating the petitioner as a under affected category. This honorable court has already categorically held that.
So let us see where is the order.
Your lordship, that is in contempt application, page 13, your lordship. And this honorable court has already clarified that portion, your lordship, in the contempt application.
Let us see.
So, directly from the page 15, paragraph 6, where the direction is there, paragraph 6.
After extracting the definition of displaced family and family.
Yes, sure.
Then you have paragraph 6, finding of this.
There is no dispute.
There is no dispute that the families of the petitioners were residing over course of 648, out of which 0.04 decimals of land was acquired. As per the definition of clause 2 of the Orissa Resettlement Policy 2006, Mediation, irrespective of his marital status, will be treated as a separate family for the purpose of extending reunification benefit. It is also not disputed that the families of the petitioners residing over the land which was acquired for the project area prior to the date of publication notification. The family consists of Mediation who were displaced from the acquired land.
Yes.
However, no such inquiry was made by the authority. Why? I'm reading it again. No such inquiry was made by the authority while extending the benefit under resettlement and resettlement policy 2006. In view of the aforesaid definition, made in Odisha resettlement and resettlement policy 2006, and as the petitioners are claiming that they shall be treated as separate families and are entitled to get the benefit of such policy, we dispose of the writ petition with a direction to the collector and district magistrate Bolangir, OP number 2 and the special area of Lawyer Sutta project Bolangir, office number 3, to inquire into the matter whether at the time of publication of notification under section 4(1) of the Land Action Act 1896, which was made in December 2001, the petitioners were adoptions of the recorded tenant, irrespective of their marital status and coming under the definition of cost to member of the family and are entitled to get the benefits of Act 2006. And accordingly, we issue notice to them. We inquired into the matter, and now the operators have found only 19% are entitled to that benefit, and
The authorities found who are the measured by the time when the 4(1) was issued, your lordship. This court has categorically held that we are all displaced, your lordship, and the writ was filed on the prayer that the petitioner the displaced comes under the displaced category, your lordship.
Where is that finding?
That is para 6, your lordship. The family was category in the earlier para, what the family has defined in the policy that was mentioned, and the family consists of major sons who were displaced from the acquired land. That is the finding of this honorable court. And your lordship, in the contempt application, your lordship, on 22nd March 2023, this honorable court has clarified that aspect, your lordship.
No, again, where is that finding?
Here, the family consists of major sons who were displaced from the acquired land, your lordship.
Which?
That page 15, para 6, last but one line, your lordship.
And when was that clarified?
That was in contempt application, your lordship.
Where is that?
Contempt application, order dated 22nd March 2023, your lordship.
Where is that order?
The para 4, your lordship.
What para 4?
In contempt number 528 of 2019.
What is there in paragraph 4?
May I permit to read your lordship?
Order?
Yes, your lordship. Once this court has come to a finding that a petitioner.
Where is that? Which page?
That is the order passed by this honorable court.
Where is that on record?
22nd March 2023, order number 7.
Case? In this case?
In this contempt application.
Order number?
7, your lordship.
But you see, page 13. Right. Para 4. A counter affidavit has been filed on behalf of the opposite parties.
Yes, sure.
Right.
Yes, sure.
You come towards end.
Yes, sure.
It is also stated that the opposite parties have acquired acre 0.04 decimals of land out of such and such, the value such and such, right? Then, thus, the percentage of loss of land is only 1.21%. Thereafter,
yes,
as such, the petitioners are not coming within the definition of displaced person under Odisha rehabilitation and
that was the contention of the government, your lordship. That was the contention of the government.
Contention.
Yes.
So, this finding has come often.
Your lordship, finally, this para 6 is the finding of this court.
Basis of this finding is not very clear.
That is the.
You are saying that this court has categorically found. On what basis? That is not very clear. Because of this counter affidavit, they have raised this issue of
that was adjudicated, and the finding of this court is under para 6, your lordship. That was their contention. That is counterfeit contention was mentioned in the para 4. Your Lordship.
What is
No,
the
but the
adjudication?
contention has not been dealt with.
Where is the adjudication?
The only adjudication was that they have not taken into account the fact that major son is to be treated as separate family. That was the only adjudication, and for that
was joint family, Your Lordship. Entire land was taken up. And after that, Your Lordship, some of them have settled somewhere else, Your Lordship. As both entire family become your landless, Your Lordship, and all become displaced. Subsequently, where they have settled, all those things come into picture, Your
where
Lordship.
is the adjudication on displacement? That adjudication is not there.
And this Honorable Court has clarified that on by order number 7, Your Lordship, para 4.
In fact, the main order cannot be clarified.
And it is further 45 said that no such inquiry has been made. That is the finding of this.
No such inquiry has been made.
Regard inquiry in respect of the majority of the claimants.
This is what we are saying.
Remand the writ application for that.
Writ application is not pending. There is no question of remand. 2016. Compliance affidavit has been filed on behalf of opposite party number 1, stating therein that the direction issued by this court as contained in paragraph 7 thereof has been fully complied with, and upon inquiry having been met, comma, a decision has been taken for payment of amount of compensation based on the fact as to decision has for payment of compensation. Stop. He has Mr. Samantraya AGA has submitted that some of the beneficiaries have been found to be major upon inquiry conducted under the aforesaid order of this court, and accordingly, payments have been made.
The payments offered, they said refused to accept, saying that this
And
content is pending.
first off, he submits that the amount of calculation, that the amount so calculated was offered to some of the petitioners who declined to accept the same on the ground of pendency of the present contempt application. So next, when counsel appearing on behalf of the petitioners on the other hand has argued that the contemners have in fact disobeyed the court's order. First off, he submits that there is specific finding recorded by the court in the order dated 4/1/2019 that the petitioners were displaced persons. First off, the petitioners have, however, not been treated to be displaced persons, rather affected persons for the purpose of computation of the amount of compensation. First off, he submits that the order of the court dated 4/1/2019 has subsequently been clarified in the present proceeding in the order dated Which order?
Order 7, Your Lordship.
Order dated
22nd March 2023, Your Lordship.
22/3/2023. Oh, stop. Next. The conduct of the contemners in complying with the court's order cannot be said to be defiant, amounting to contempt of court. So stop. The question as to whether the petitioners were displaced persons or affected persons, comma, in our opinion, can be, in our opinion, not addressed by this court in the order dated 4/1/2019. Oh, stop. In such view of the matter, while dropping the present contempt proceeding, we grant liberty to the petitioners to question the correctness of the decision taken by the contemners while computing the amount payable to the petitioners as affected persons instead of displaced persons. So we make it clear that we have not gone into the merits of the rival contentions as to whether the petitioners are displaced were displaced persons or affected persons for the purpose of computation of amount of compensation. This application stands disposed of.
Mr. Mahapatra, you have argued that they are not only persons affected, but also are coming under dismissal. Both way you have argued before the court. That is para 3. Learned counsel for the petitioner submitted that since the land of the petitioners as well as their dwelling houses were acquired for the purpose of construction of such and such irrigation project, they are not only affected persons, but also are coming under displaced person within the meaning of clause 2. That is your argument.
Item number 35.
We were waiting for you.
Item number 35 here, after notice not rendered. My number item 8 is a fresh admission and only limited, and as because there is summer is going on. And at that time the drains are comparatively visible and easy to inquire and do the work. But when rainy season comes, it will be pushed up and cannot do work. One new project has been invented by the petitioner number 1. And that has been given in pen and paper. And there is a prayer that it should be visualized in electronic projector in presence of, we have to all the persons, collector, commissioner, mayor, and all the secretary, but it has not been worked. So I will seek the permission and direction from the honorable court that the collector may kindly direct it to make availability of this projector with the technician and all these persons, including the water resource chief secretary, urban development chief secretary, and I also request one of the judges from sitting judges. I would like to Justice Raman may kindly be deputed as the commissioner.
So you don't have faith in the chief justice?
So that can be. Because your lordship is seeing the matter and understood the matter, that's why it will be easier for him, and that will make it complete clear within 5 years.
All right, let him argue first. Let him say first.
Time will be over, Miller. That's why.
No, time is the 15 minutes still left. Where we will be here till 4:30.
The box drain is completed, but it could not function well
It is not yet complete.
because
It has not yet been
because the rain burst, the cloud burst that day,
My lord.
that again created problem. Even if box drain is stated to be completed.
No, my lord, it's not yet
And
complete. It's not complete.
Many newspaper
I don't think those
agencies have
reports.
published that
Part of
Answer
the,
portion has been inaugurated.
some portion they have completed and inaugurated.
My lord,
The fact in dispute.
my lord,
that
810 meters.
my lord, let me be
Please,
permitted.
please, let me appraise. Let me-
My lord, out of 2,590 meters of the box drain, is except 70 meters, all have been completed. 70 meters is to be done.
Now
by
70 meters.
70 meters should be done by 10th of May. The delay because there was the Dola Purnima and the inauguration of the project. The half projects have been done. They have been inaugurated in the February 29th. That's why the delay is done, and this will be done by 10th. The rest
Because
about
of inauguration,
810.
the projects are getting delayed.
Yes, ma'am.
No, inauguration is to be done after the completion or before the completion.
Before the completion.
So inaugurate the things before.
They have inaugurated the order.
Huh?
They have inaugurated that, or whatever the work they have done till that day they have inaugurated. Because for the elections.
Unless it is completed the project, prior to that,
That
2
they
months
have-
before,
They have
they have
inaugurated.
inaugurated this thing.
On
When it is a disputed
All right,
fact,
all right. All
Then,
right.
my lord,
Just a minute, just a minute. Point one by one. This box drain.
yes, ma'am.
Box drain will be completed by
by
10th
10th
of
May.
May.
Last 70 meters should be completed by 10th of May. By rest about 810 meters, which is open drain, which there is a lot of scarcity.
So who is saying this?
810
That it will be-
meters. After the 2009, 2,590 meters, the box drain
Who
closed
is,
there.
who is saying this, that it will be completed by 10th of May?
By what? By what co? By what co? CO what co?
What
is,
represented by-
Watco is the represented by the lawyer, my friends, and Watco is the CO is telling. Yesterday I have gone to the site,
Mr.
discussed with the
Amekasuri,
engineers.
Mr.
Then I
Amekasuri,
tell you,
Mr. Manti, Mr. Manti, this should have been by way of an affidavit by Watco.
no, this is my report. This is my
You
amicus
are-
curiae is giving this.
See, how can you vouchsafe
All right, all right,
assure that
all right,
this will be
just a
completed by
minute.
10th of May?
Just a minute. Who is appearing for, what is this Watco?
Yes, my lord, so I am happy.
What is Watco?
Water corporation.
Water Corporation.
Yes, ma'am.
So how much time will you take in completing this box drain?
Will take 10th May.
10th May?
Yes.
You will complete. And this open drain?
Open drain,
Open drain, it is a policy matter of the government, my lords.
open drain, it will be completed after the rainy season, my lord.
After?
This will be by, they are telling the Wadco CO I discussed, he is in hospitalized. The CO of the Wadco is hospitalized.
We can appoint, the court will appoint.
No, I have.
Some CEO,
No,
if the
no.
government is not appointing.
The CO has told me that the 810 meters will be completed in before March of 2025. Because after the rainy season, it will start.
If you don't assure to complete it,
During rainy season,
How this covering of the open drain
now
will help water problem?
waterlogging problem is a great problem, Scott of Mila.
Huh?
Now, after the box drain is completed, there is a pumping systems. Five places,
So
there is a
therefore-
pumping.
Therefore, for water logging issue,
Yes, ma'am.
box drain is more important.
After the box drain is over and 810 meters is over, and with the pumping station which is working now, 5 pumping stations has been done. There will be no waterlogging in Cuttack. That is as they have assured me. And what I have felt, I have also discussed yesterday.
Just let
Yes,
me
ma'am.
understand this
Yes.
aspect, that open drain
Yes.
has nothing to do with the problem of water logging. It may have other problems.
Yes,
It may be required to be covered, but
Yes.
otherwise for hygienic.
My
issues.
lord, that is whatever they have suggested, we have gone to the site. Why you have diverted instead of a Boston to open drain? I have already told my lord, because there is a narrow.
May I be
all this-
proposed there?
Let me tell you that we have discussed. I have discussed with the engineers and also the people who are residing there. We are trying to 2 or 3 steps, 3 designs we are contemplating. 3 designs. One of the designs will be taken off, which will not be, which will prevent the people what they are apprehending. That will not be there.
Just a minute. Can we take this from you, that you will be completing this by 10th of May?
Yes, ma'am.
Just a minute, Mr. You are
Yes,
representing
my lord.
Qualification. You will be completing it by 10th of May. And with the completion of this bog drain, there shall be no issue of water logging in the town of Cuttack.
It will not be done but this year, my lord.
Not-
It's not possible this year, my lord.
Why?
Waterlogging will be there Because when the open drain is there is a level of 4 meters. The ground level of the open drain and the box drain, there is a 4 meter. There was stacking of water. But yesterday I have also discussed what this year, what will be done, because that was a program that 810 meters will be completed by June. They are now delayed. But that the Kotak will not suffer. The people should not suffer. So that arrangements has been done. So that during this construction, whatever we have done 810 meters, suppose we have done 200 meters. Suppose we are out of 810 meters, we have completed 80 meters, another 100 meters we are expecting to do it. There will be a gap. In that place, there is a 4 meters difference. So it has decided that is a lot of pumping system, pumps will be arranged, and all the waters which is coming through the box drain will be pumped out. That has been decided.
This matter will come on 11/5/2024.
Yes.
All right, we are adjourning this matter for 11/5/2024 for Watco to report to the court that this has been completed. All right.
Yes.
Two, from 11th of May, we shall be regularly monitoring this case
Yes.
on priority basis. All right.
Yes.
Your lordship, there is
And this no work should suffer because of any inauguration program.
My lord, I am trying to discuss and finally.
And if because of any inauguration program, this is to suffer, the court will stay any such inauguration function.
May I, my lord? May I, my lord?
May I be permitted to submit?
Yes. So let us see.
So far this,
Please submit on level.
my lord,
lordship.
today for a moment, my lord, it is required, my lord, because it is some facts are submitting which is not relevant to this present case. Why I am saying, my lord, my humble submission would be this box drain concept was developed since 10 years back, my lord. It is started from Samaj office to Matru Bhavan. So because of this line is the lifeline of the Cuttack city, and for the purpose of drainage of waters and waterlogging system and the hygienic system. For this purpose, with a IIT recommendation, these things has been taken care of by the government, even though time has been lapsed. Still process, the drain will be covered, number one. The road will be widening, number two. The hygienic process will be completed by this process. And so far this running and flying of the vehicle, it will be more convenient for the 1,000-year millennium city. My lord, that exactly I am coming, my lord. By this process, whenever this starting from Samaj office to Matru Bhavan is there, before that, all of a sudden they have changed the original plan and the box drain system is to be completed as per their argument. My learned senior is the amicus curiae in this case to Chhatra Bazaar. And with a hasty manner, they have inaugurated though, even though it has not been completed and the residual part 810 meters is still to be completed. Apart from that, there are two categories of drain. One is open drain, another is covered drain. Then third one concept is a box drain.
We don't have any kind of magic to do. We will have to.
My lord, before that also, my lord has taken the indulgence and as per their report, they are saying
See, we the court commissioners have submitted 2 reports with respect to the works undertaken by R&B Division 1 and 2 as well as CMC. The complaints we have not yet received and what action they have taken upon our report, that is to be informed by the state opposite parties, that is R&B, that is there, your lordship. That report is with regard to the conditions of road and as well as sanitation and garbage in the state, your lordship. Yes, your lordship.
That compliance affidavit we have filed and serving a copy to my company.
My lord, from my side, from the CMC's side, that affidavit has not been filed yet. I have received about 40 photographs and instructions last evening. I'll require, my lord, some time to compile that information and present it before.
You are CMC.
My lords.
Not grant even.
Maybe pardon, my lord.
My lord, my lord, 2 minutes I will take. Out of this open drain of 810 meters, after that 11 kilometers is the open drain.
I have not been able to understand every aspect. Just
My lords, one small prayer. My lords, I'm a little personally not available tomorrow, my lords.
Ask someone to bear.
My lords.
This is very important.
Maybe pardon, my lord. My matter may kindly be taken over the fresh admission. If it will internally, it will take time and cannot be completed.
This case along with this.
No, my lord, not with this. Fresh admission, so that my matter.
After all, order will have to be passed by us.
My lord, my submission
got
to
it.
the lordship is that it is they are working like the area of problem solving without formula. We have the formula, my lord. We want to extend our helping hand to them.
Tomorrow after lunch.
Everyone has one formula.
No, my lord, it is implemented. That's why we want to extend.
We will see tomorrow.
Well, item 37. Next one, item 37.
Yes.
I mean, some difficulty tomorrow, Monday, 2 p.m.
Monday.
Grateful.
37 is what?
That's writ appeal, there's a batch of writ appeal.
Item 63, I pray for tomorrow, Your Lordship. Item 63.
My lord, item 40 paper tomorrow, already argument has over, my lord.
Item 43, man. I have personal difficulty. Let's come Monday, man.
He says I'm not.
Yeah, item 63, I pray for tomorrow, Your Lordships.
Item 43, let it come Monday, man. Item 43.
It will be there tomorrow. Tomorrow you may come here and we will adjourn. We are very liberal in adjournment.